Do you speak English, ma'am?
I understand better less.
I'm sorry?
I understand.
Ma'am, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. We're going to do probable cause to see whether we are going forward with the case or not.
On 7/1/2025, CW stated he arrived at work at HEB located at 10919 Louetta, Harris County, Texas. CW stated another vehicle sideswiped his vehicle. CW then got out to observe the damage. CW defendant then drove. CW then drove after defendant. CW began honking at defendant. CW drove alongside her and tried to flag her down. Defendant took a sharp turn in an attempt to evade. And CW took a picture of defendant's license plate and stated he observed a white female with blonde hair behind the driver's seat. Officers observed the suspect's vehicle was involved in a Class C offense. The defendant as in a Class C offense. CW's ID, the defendant from a photo. The total damages were $1,000.
Did you say that she hit?
She sideswiped him.
Oh, sideswipe. At the HEB?
Yes, Judge.
Okay. Does she have a license?
Yes, Judge. So they just.
Ma'am, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you are ordered not to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes.
If you violate these conditions, if you pick up a new case, I will revoke your bond and put you in jail. Do you understand, ma'am? Do you have the ability to hire a lawyer?
No,
What do you do for a living?
I'm retired. I get $770 from Social Security.
Okay, we can have you apply for a court-appointed lawyer. I need to know everything about you, and then we'll take a look to see whether you qualify. Deputy Williams will give you an application, and we'll have you sign a receipt, and then we'll have you take a seat in one of the pews over there, please. Please.
All right, Judge, top of 14, McMurray.
Ma'am, you were charged with terroristic threat of a family or household member. That makes it a Class A misdemeanor. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On or about November 4th, 2025, the defendant, along with her children, was picked up by her mother, the complainant, and brought to the complainant's apartment at 1801 Smith Street in Harris County. The defendant became angry at CW for statements about her living conditions and stated, "I will slap you and I'll kill you," with profanities. The defendant also was swinging and charging at CW. The CW asked the defendant to leave, and the defendant left with the children. The complainant then called the police. Officers presented the CW with the defendant's date of birth and driver's license number and positively identified her daughter as the victim.
Got it. Ms. McMurray, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with this complaining witness and not to be in possession of any weapons. I am entering now what's called a magistrate's order for emergency protection that identifies Ms. Britton as a protected individual. You cannot commit family violence or an assault against this person and act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Smith apartment 911. If you violate this, they can file additional cases against you, and a violation of a protective order is the capital murder of misdemeanors. You understand? I have no problems putting people in jail. I have no problems making your bond $50,000, $100,000, $500,000. I will protect my community at all costs. Do you understand me? Do you have the ability to hire a lawyer? What do you do for a living? Why would you just stop working there?
It was like problems with the manager and stuff. We ended up getting new managers, so we just got like messy.
Most people will get a new job before they leave an old one. It is time for you to get a full-time job. And I am also making that a condition, and I'm bringing you back in 2 weeks, and I want to see what you have done to get a job to the tune of around 15 to 20 applications. Do you understand? All right, we'll have you fill out an application. We're going to have bond conditions created for you to sign, and then we'll have you take us in a few minutes. Please.
All right, Judge, next is bottom of
If you can file
19, Rodriguez.
no weapons, no contact, please. She needs to sign up the MOAB too.
Yes.
Deputy Williams, she needs to come up, sign the MOAB. What did you say, Victoria?
Rodriguez on page 19.
You speak English, sir. Mr. Rodriguez, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On or about August 8, 2026, officers responded to a crash at 900 block of Gregg Street, a public street in Harris County, Texas, where officers identified the defendant. The defendant stated he was operating the black Cadillac Escalade. When he crashed, officers observed a strong odor of alcoholic beverage and slurred speech from the defendant. The defendant refused a standard field sobriety test and refused a blood sample. A search warrant was obtained for the defendant's blood and results are pending.
Did they do any field sobriety tests?
He refused.
Oh, he totally refused. Got it. All right. Mr. Rodriguez, I'm going to find that there's did you say there was an odor of alcohol?
Odor of alcohol, slurred speech.
Got it. And then the accident. Got it. Mr. Rodriguez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. Because this is a second offense, I'm now ordering you not to drive any vehicle that's not equipped with an ignition and a lock on it. If you're caught driving one, I will put you in jail. You understand? I'm putting you in jail regardless today. You have an open felony warrant. Your bond denied on the felony, so you will be going into custody today. We'll appoint you a lawyer, but I'm serious. You endanger my community. It's just not going to go well for you. Do you understand me? Does he have a license to drive? You heard from Burnett.
He was here earlier. It's a legit motion.
Okay. I'm waiting on Mr. Burnett. Give me 5 minutes. I'm gonna see if he's out there and then I mean, we've got a panel, so we're ready. All right. Go. Yeah. Of course. So let's have him sign conditions and then we'll put him in custody.
All right, Judge, next is page 23, Vega.
Can you file the guardian interlock paperwork?
Vega, yes, Judge.
Good morning, Mr. Vega. Sir, you're charged with driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On 8/18/2026 in Harris County, Texas, officer observed a white Nissan with an expired registration and conducted a traffic stop. Officer ID'd the defendant by Texas driver's license. Officer then ran the driver's license and observed that his license was suspended beginning on 5/5/2026.
What,
It was expired registration.
got it. All right, Mr. Vega, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to drive any vehicle whatsoever for any reason. I really don't give a rat's behind what you have. Look at me. You really don't care what you have to do in this life. I don't care that you have to work. I don't care that you have to go to school. I don't care that you need groceries. I don't care that you have to go to the hospital. If you don't have a valid Texas driver license and liability and approval from us, do not drive. You will be signing an affidavit with me today. This is a promise that you're going to make to me that you're not going to drive. If you do, I can have a contempt hearing every time you drive. You can be slapped with 180 days and a $500 fine. Do you understand?
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us, and then we'll get you to sign a reset, and then we'll get you out of here. When you come blank, please have a lawyer.
Yes.
Okay?
That's it for now, Judge.
So.
Person waiting?
Yes, this is. Or adjourned, not operating on the before that.
Yes.
Yes.
Oh, yeah. Why does Monday for Lisa? No, I haven't noticed that there is such a Davila?
Good morning, Mr. Burnett. It's David Fleischer. It's 9:10. We are ready for you. We've got a panel. Would you mind coming to court 5? Thank you. Hey, do you have Silva back? Silva
Oh, Silva.
in the jail? She's on the docket today. She shows she's in custody. Silva?
Yeah, in custody.
Okay, don't send her down because we need to talk to her, please.
All right. Go ahead and try to clear that. And slide on what?
So we can do
Mr. Burnett, can I borrow you for a second, please? I need you to take a look at the jury list so that we can go get the panel. Shanti,
Yes.
we need to give you the jury list. Mr. Burnett, Mr. Burnett, take 5 to take a look so we can go get them, please. Thanks.
This case, I just don't know this. It's so hard.
Jackson should be raise your right hand. You solemnly swear or affirm or make sure that nothing is true. Okay, yes. Absolutely. This is an off-property change.
Sure, what is this?
2627493.
9-3?
Yes. Martinez.
Okay,
I was trained in one this morning, saying that, we approached you last week about getting a screen device and allowing him to drive trucks for work if he provided with you the phone.
yes, I remember.
He did provide that proof, this morning. I was not informed at that time, so I just wanted to verify if that was.
But I'd like you to first verify with the work to see.
We
Yeah.
did verify, we got the, letter from his job. Would you like to see it?
No, but have you verified with the job?
We're gonna call the job.
Mhm.
No, HR services for all job agencies, specifically, job. I believe the case managers that you can call right now.
Can or cannot?
They are able to, I could see if I'm.
Yeah, please, that'd be great. I just want to verify that it's actually true, correct, and then go from there. And then if that's the case, then yes, he still has to have the interlock on his personal vehicle, and then he has a scram, right? He needs a scram.
I'll see if we can get that, call done right this second.
Okay, thanks.
Yeah, and yes, it's first one with me.
Guys, do you mind grabbing Mr. Burnett? Mr. Burnett, do you mind grabbing him? Okay, and he's like a shuffle. He's like a shuffle. Hey, we need your jury list back. He's doing a shuffle. Etch, he's shuffling real quick, okay? Yeah, I need your list back, please. No, I think you're good. We're going on Mr. Burnett's case. Are you going on 6 or no? Are you going in 6? No? Are you going in 6?
Yeah,
Okay.
I mean, we haven't ever said, but Shelby said, no, I'm sure he gave me a new date, but said.
I guess we did the 22nd for the last one, right?
We said one yesterday, yes, we did on the 22nd.
You want to do the same day?
I think we said one on the 29th. September 22nd. We can do the same day. I don't have any thoughts on that day, but I have some.
Yeah, I know.
The day before.
Right.
Just have to tell you.
Yes. Okay, got it. Yes. Want to call them to sign?
Judge Fleischer.
All this could do with not being it's not gonna go strong, but we got one of those testimony for days.
Yeah, all right, you'll sign just a minute.
Are you planning on doing a PowerPoint?
Yes.
It doesn't work on a Mac. Do you have a PC? It will not, the system will not recognize a Mac. It only does PCs. Even with your dongle, it will not work.
Is it a PowerPoint yet?
Yes.
Yeah, so, right. With them, they'll usually pretty good. They're,
And I'll leave it for on everything. I'm thinking junior this week, it's for the one.
hey, hi, Ally.
I was just approaching on the other trial case and my other trial
You
case.
can reset it.
Okay.
Yeah.
Thank you.
Just, how old is your case?
December.
So, yeah, 30, 60,
Thank you.
for sure.
So we're up. Okay.
Hey. Marcus filed a motion to withdraw on Velasquez.
Yes.
Did you
He
appoint,
told me this morning. Yes.
did you already appoint or no?
It's going to the PDO's mental health.
Huh,
So
okay.
As soon as Sebastian.
Should I go ahead and grant it?
Yes, yes. State defense. Costa. Thank you. This way.
Michelle, yeah.
Okay, decided. Oh, no.
Did you run it already?
No, Judge,
It's going
I
now.
told her that I was shuffled. Yes, you need to. Didn't need it. Yes, if you all are safe space, you have to be transparent. It's been. I'm not sure. So just It's kind of get the content. Right, they look pretty.
Thanks, Edge.
Okay.
Here, you can have mine.
Oh, you want this one?
No.
You want this?
Oh, that one? Okay.
Yeah, that's. The last part of the amendment, you said I. That is on. I'm assuming that's on. If I'm not, since you don't have that. That's correct. That's that you want.
Okay.
Excellent.
Yeah, that's what I'm actually. Not to confirm, what they were set up to. But of course, it's like you don't have any document. Yeah. Yeah. Yeah.
Harris,
So like, I would just means this few language.
Yeah.
Hi,
Yeah.
come on up. Who you got? Did you just get appointed?
I'm sorry?
Did you just get appointed?
Yeah, not too long.
Oh, it's just an old case, sorry. It's from 2025. Okay. What do you want to do?
So Judge, it looks like, we're talking to mental health in regards to potentially jail reentry. My understanding, speaking to the defense and also speaking to, our back spoke to the complainant, will indicate that the defendant went to a long-term treatment facility. And they have been doing some like mental health assistance in jail.
Great.
So Lawrence has been working on it, trying to confirm those details and see what he's gonna do. We just wanna like.
I'm down as long as they pick him up and take him.
Yeah. So
Not
that's
on his
we wanna
own.
let you know that it might be something that she'll put in your queue while.
Yeah, I'm certainly down with that, as long as they take him, because I don't know if we can trust him to go on his own accord, so.
I don't think it's a matter of trust, but I do want to make sure it's housed. That's the my focus and making sure it's housing.
They only do for so long, unfortunately. It's not,
We have other resources, we have like social work, we have resources. Yeah, but sometimes.
so you're not talking about the Ed Emmett Center, is that what you're saying?
I'm doing that right now. But I've also been doing something about the future.
That'd be great, because the Ed Emmett thing only lasts for, what, a day? A couple hours.
We can go for a couple of weeks and then there's some things that we can do there, but.
Okay, yeah, I'm, regardless, I'm down. And then, Veronica, we will need probably a PR bond for Mr. Smith.
But once she does that, Judge, we can email and then let you know, like,
Yeah.
it's gonna be in the queue.
Okay,
and
so
then,
just
we'll do the
be on the
PR.
lookout and be ready. At some point, we'll get the jail release instructions and then we'll have to process that PR bond for the next day for the 2 PM thing. Okay, cool.
Yeah. Thank you, Judge.
For sure.
So hopefully she'll get back to us soon. Thank you. I'll let them know.
You said both are on board?
Yeah. Okay, then everyone, yeah.
I just think this.
Judge, do you have a financial affidavit up there?
No,
Melissa, do you have?
I do not have one, no. Do you know what specific name?
Miss Murray?
No, I think she's still filming now.
Oh, are you done with your? Yes, come on up, please.
Judge.
Yeah.
You want a quick signing modifications?
Yeah.
I was able to verify that there's any clear information.
One, okay, so let's do the scram and then we'll allow them to do it. Okay.
Yes. So the second hand, and whether, no. That's the part. That sounds like I'm kidding. You never know. Vega?
Yes.
No, no, I could put it there for. There's a copy of your alteration. I need to be split with your next. Yes. Anything step, but then that's the thing.
It's great.
Here's the. But.
This, is this the new list?
So, yes. Actually, you get yeah.
Mr. Jaworski, hi.
Yesterday when I zoomed in, The long court.
That's all right.
But I did have.
We're happy to have you.
So set for trial, Villa Real, and
Let me
you said you're gonna reset it.
Yes, let me just see how far, because,
What date are you?
yeah, probably like 30 to 60 days,
Okay,
give or take. Yeah, for sure.
Thank you.
Yeah, of course.
Maybe
Shoot.
the other train that for Bulgaria, I don't have the date. Do you know who it is?
Who it is?
The gentleman that showed up for Mr. Garcia. Who said that the Gary, the guy that has the two other charges.
Oh, do you have the cause number to the case?
I have the customer, I have only the Gary's email. I don't have the other guy's email.
What do you mean the other guy? You have DeGaren's email?
I guess I'm just saying.
Yeah. Well, that's the only one on the case, right? He's the only one on it. He's the hired lawyer on it. He's got, I didn't see anyone else on the case.
I'll put that then.
Did you get a,
Right.
really? Okay.
No connection. Sorry. So I'm letting him know.
He's gonna be blown away by that one.
I know. Simon, just a minute.
This one.
All right, go ahead and sign. I don't think so. Yes. Okay. I would just, you just leave it there, it's not, just double check it, so we do it on the bottom. Sometimes I get started. How's, so, from the office, they emailed them 7:30. So, 17 or the chunk board?
The 24th.
When I hang it out. Maybe it's very famous.
And this is well, I think the candidates. Yes, yeah, I'll, 17 or 24.
17.
Alright.
Basically, we're trying to think right now, we're just sitting.
Where's the zone? Oh, okay. Okay, see. Yes, supervision order is supposed to be back today. November 22nd. Yes, that we will have to do in 20.
And does it?
That one will. And we're just September 29.
That's it, I'm not doing that. We said we have Wilson, Jackson, from them. Actions, especially, and
Hey, morning.
I'll be showing the case to today with Mr. Barnett.
Okay.
I want to make sure you put.
Yeah, absolutely. Of course. Sure.
Thank you.
Yep. Are you,
7 weeks.
Mr. Weeks, are you,
City second.
Yes.
Okay.
he's doing word art though.
Yes, sir.
Got it. Okay.
Before we begin, we just want to address some prior preliminary matters.
Okay. Let's do it now while we're waiting. Mr. Burnett, can you come up real quick? All right, guys, we're going on the record. If you need to talk, use a phone, please go outside. Ramona, you ready?
Yes, sir.
All right, we are on the record in cause number 2610088. It's the state of Texas versus Janae Green. It is approximately 9:42 in the morning on August 25th, 2026. First things first is let me have you guys announce yourselves for purposes of the record. State going first,
Shakir Shaw for the state.
Karina Batista on behalf of the state.
defense.
Ari Burnett on behalf of the defendant.
Zane Weeks on behalf of the defendant.
Okay. I see a whole host of motions that you have filed. Have you filed any motions, state?
No, Judge, but I had one, oral motion based on, checking defense's, word art tonight, and we discussed it, and I think we're not on the same page, so I just wanted to bring that up.
Okay,
Defense wants to go into, effects of, concussion on someone during the word art. There is really no evidence in this case that there was a concussion. The defendant was thoroughly checked at the hospital, had a CT scan, and there was no sign of concussion. So to bring that up, it will just confuse the potential jurors, put the seed in their head that there is probably a concussion there.
was there an accident in this case?
Yes.
3-car accident, Judge.
There was an accident, yes. She does have a black eye or a contusion as, defense put it, but there's no concussion.
Judge,
There's a huge difference.
Are-
we would also say it's improper for dire. There's not going to be any medical testimony in regards to that. With regards to the purposes of voir dire is to talk about their opinions and to talk about the law, not to be talking about potential facts in the case. And by him mentioning concussions, could potentially go into facts that may or may not be true.
And Your Honor, it's my argument, first of all, that I think it's wholly relevant. She has a large contusion on her face. It's a 3-car accident. Multiple officers state that she has likely had a head injury. She was just in a car crash.
But you can't get into the facts of the case.
I'm not getting into the facts of the case, Judge, but I do think it is important. As far as it goes, as far as SFSTs and other things, it is a head injury is something that is to be considered when it comes to a person's normal
So
mental and physical faculties.
I agree that it could, but I think that you need to be very, very general if that's what you want to get into. Don't start
Absolutely.
mentioning contusions or start mentioning
I plan to talk about, on that slide, I just plan to talk about college football, Judge, and it's a little bit of an icebreaker for the jury. And
I'm okay with it, but I don't want you to get into the
I
facts.
won't speak.
One at a time.
My apologies.
Go ahead.
But no, I don't plan on even bringing up car crash or contusions to the jury in the sense of that nature. I just want to ask about mental and physical faculties and what they believe a head injury may show. But
I think that, if you're going to get into specific facts, that's, I think, off limits. So I would, especially if you don't have any kind of Are there any medical records that have been filed in the case?
There are medical records and she has been cleared for concussion or any type of head injury other than the contusion.
I mean, certainly, I think car wreck, I think that's okay. But if you start getting into concussions and contusions and to scrapes and head injuries, and that's getting more into the facts of the case. But I think generally speaking, car wrecks, ladies and gentlemen of the jury, what things may happen when you have a DWI. Someone, okay, well, this, potentially car accident, okay. And then, but don't get into real, please, specific facts.
And so that's why we're objecting to specifically the slide that he has about football players and concussions, because that's going to go specifically into a type of potential medical issue, right? If you're talking about like how you say during the slide, when we talk about mental, physical, what can hinder the mental or physical, generalizing, but to specifically have a slide dedicated to concussions or contusions, I think that's improper for hire.
And Your Honor, I would completely disagree. I think the defense has a right to voir dire on any issue that could come about, especially when we're talking about a case that did have a car accident, a 3-car accident that was really bad.
But what does football have to do with that?
And I think that is the way I was able to keep it generalized. And there's a lot to do with head injuries and how that can affect STs,
but
how these things can do. And I think I'd have the right to voir dire on that in any DWI case, even if there wasn't an accident or a concussion. I think I would have the right to ask the jury, what is a person's normal mental and physical faculties? How could a head injury affect that? What might you see that would give you some
I agree with you.
details? I plan on
But
keeping
just
it
don't-
general. I don't
Don't
plan
get
on
into
doing that.
concussion, don't get into contusions, but car wreck's certainly okay. If you want to allude to football, okay, I mean, I think that's a little out, but okay. But, can you take it out of the slide?
I'd like to. I think
Could-
I have the right to
Will
voir
you
dire.
take it out of the slide, please, as far as concussion is concerned?
Nothing in the slide says concussion. It's just a picture of Tua Tagovailoa.
Can you show it to me real quick?
Yes, yes. And it says CFB for college football. But regardless, I think it goes to more than just whether or not she has a concussion, but it goes to
I'm
things
not,
that the officers ask.
I agree with you, but in voir dire, you can't get into the facts of the case. That you can develop it through testimony while in trial.
Well, I would ask that the state not be allowed to talk about any of the car crashes. I believe, what slide was that?
Well, but if you're gonna talk about car crashes, then they can talk about car crashes,
Well,
right?
I think if they can talk about car crashes, I can talk about possible concussions.
We don't have anything.
Okay, so just please don't talk about concussions, okay?
And I'm still just not understanding the
So
possibility.
you have a problem with this?
That's what they have.
Yes,
Well,
there's-
when I asked, because I didn't know what that was, and when I asked what it was about, I was told that there was gonna be a discussion about concussions and how that could affect
Okay.
somebody's mental and physical faculties, and I'm just saying there is no concussion here, so to get that plant that seed in the jury's mind that there's a concussion involved here.
Please do not get into the facts of the case.
I'm not going to get into the facts of the case, but I do believe that the SFST, the manual that the officers read from, do tell them that they're supposed to check for these things. They're supposed to
And
ask
yes,
for EMS.
I'm not disagreeing with you. In trial, on direct and on cross, yes.
I believe it's a proper voir dire question
That's
if.
improper.
You-
Voir dire is talking about the law, what the law is, and getting their opinions on the law, not telling the jury what you believe the law should be or what you believe are relevant and issues to this case. So that's why we're arguing with improper voir dire when it comes to the concussion, because you're implanting to the jury that a concussion is going to be involved in this case, and you're going to provide opinions as to how that might affect the SFSTs instead of letting the jury provide their opinions, what can cause issues. You're providing them with the law, that your interpretation of the law, and that is improper voir dire. That's not, you have to give them the law and provide their opinions in regards to the law. It's to determine whether or not they can follow the law.
And Your Honor, I believe it's very easy for me to stay away from me mentioning it, but if I have a juror that knows who that is and mentions something about a concussion or anything, that's not a problem with me. I have the ability to voir dire on whatever I want to voir dire on, as long as it's not the specific facts. And I believe the protocol that the officers are supposed to go through, what they're supposed to check for, the things that they're supposed to ask and ascertain prior to SSSTs or getting these sort of results, is checking people for concussions or head injuries of any kind. And so I believe if I ask anybody, hey, who likes college football, and who knows who this is, and why could something like this be important to a case? I don't see that there's any issue with that, Judge.
Okay,
Judge, if he points out a particular football player who had a concussion and issues, that automatically puts that seed in.
And as you said, we don't have.
stop. I'm going to sustain it as far as just as the concussion is concerned. If you want to allude to something, but don't start suggesting it, please. Please do not get into the facts of the case. Get into the law, generally speaking, with DWIs and just like everybody else when we try a case, okay?
Judges, based on his comments, we're also gonna ask the motion only that he does not talk about what the law enforcement is supposed to do, or their manual, or SFSCs. That's more of a fact issue. That's something for the jury to determine the credibility of the witness when they're on the stand. Not to start talking about police officers have a manual that they have to follow and all these things. That's not a legal issue. That is more of a fact.
It's getting into the facts of the case as well.
Your Honor, that's as general as it can be. Every single case has those same general protocols.
I've been trying cases for 25 years. Never in 25 years have I ever heard someone get into the manuals in voir dire.
And
I'm telling you, it's just.
that may be those people, but I don't plan on asking those specifically saying manuals, Judge. But I do think I have the right to ask the jury how they think a car crash could affect someone, what type of things happen after a car crash, what should we be looking for?
Mr. Burnett, I would like to try a clean trial. I don't want bickering back and forth. I don't want pushing of the boundaries. Please, I'm asking you, make it a clean trial, okay? You know how to try a case. You've been doing this quite a while. What you can and can't get into in voir dire, I'm not asking much. I'm only asking you to follow the law. Please. Okay, don't get into the manual. Don't get into this. This is stuff that happens when you're on direct and when you're on. Okay. Anything else?
Judge, do you want to address the defense's motion in limine while we're also?
Yes.
I was intending on addressing the two on one, Judge, but.
Is anything related to voir dire?
Nothing to voir dire.
Do you have a problem with any of his liminees now? Have you seen?
I was under the impression just to the jury.
Yeah, if that's fine. If you want to do it tomorrow, we can do it tomorrow
That's
as well.
fine, Judge. We can do it tomorrow, since he's
Okay.
thinking that.
I guess take a look at them to see if you have any problems with any of them.
Yes.
Do you have any other motions that you want to file or that you want to?
There will be some more.
More? Okay.
Yes, Judge.
I don't see any orders, Judge, so, because that's the last one I was able to check what we agreed on, didn't agree on, but I'll just circle whatever we don't agree on.
Okay.
Yeah.
Okay. Panel should be here any moment.
Thank you, Judge.
Okay. Hi.
Your Honor.
Morning.
Mr. Trahan, Your Honor.
Okay. Where are we at with Mr. Fagan?
I feel it's a great trial case for us. Do we have everything? Sorry. Don't we step to the side of that?
No, let's take care of it now. Do you have everything? Are you missing anything?
Recall, everything seems to be complete from what I can see. 911 is in.
Wonderful.
Yeah, everything's in.
Okay, do you have an offer on the case? So we'll give you another reset at the next setting. They got to be here to let us know what they want to do with the case. Victoria, bottom of page 22. 30 days must appear clear trial. All evidence is in and offers made. Please.
Have you seen her?
Thanks. Have a great day. Hi.
Good
morning.
I've got, two of them set for trial. Victor Gonzalez and Marlene Alvarez.
Let me see. Gonzalez And who is the other one?
Alvarez.
Okay, pick 30 to 60 days. We're in trial on another case
All
now,
right,
so we'll just reset you 30 to 60 days. You
And
pick
I've
it up.
got one, Wilson, that was a writ, Eddie,
It was a what?
a writ, Eddie.
I'm gonna double check.
It's 222 days. I'm not,
I'm playing that up, Judge. So Judge, let's say we spoke to them in January, but they didn't get any estimates or information. So that's what we followed up on, and we did not get an answer. That's the voicemail.
so cut it loose. It's 222 days. It's not,
You have to confirm, because it is a criminal offense, whether or not there was any restitution, if you can get one more setting to.
No. no. It's 222 days. It should have been done way long ago. It's over.
I can make an offer to not include restitution, Judge.
Right.
Okay.
So we'll give you up until next week. Your client's got to be here at some point next week to take the case, either accept it or we'll set it for trial.
Okay, so we'll come back in a week on this one.
Yep.
We said the other one for
Yep.
30 to 60 days.
Okay. Fine.
What about for council, bottom of 3?
You have another one. Caldazo,
Yes, that,
Cadalso.
For the email, they were working on mitigation.
yes, that this was trying to, I'm gonna confirm that.
Please, it's 170 days old. If you need a reset, it's only going to be a couple days around.
And then the last one, I guess, was Davila.
That was at, bottom of 3, he has 2 different last names.
Oh, okay, that, okay.
Got it.
So that's what that is.
I'll work on it.
Discovery's complete. On that
Yes,
one?
Judge, discovery is complete. Everything is in photographs and everything. like
Great.
that.
Okay. Do you have offers on the case?
Not at this time, but I will get with the judge.
Please,
Yes.
at the next setting, which is about a week, clear trial. So if you want to submit the mitigation, do it within the next couple days, please. Okay.
Then top of 4, Judge.
Ay, caramba.
He had one.
Same thing. What do you want to do with Calvo? It's 180 days. It's a
I'll
DVR.
work it out. So if I do-
Okay.
After you said it a week, I could try to do that.
For
Well, I can
the
look at it today.
email, for
That
the
one has
email,
an
a
offer.
supervision order was to be filed today.
For Chicago?
Yes. From the office.
Did I just have one?
Application was submitted on 8/11, approved. The TRAS was done on 8/11.
Contract was received August 21st.
Wait, I sent that, hold on. For Chicago, I see that the contract was sent to Fence on the 21st. Right, we have not it back. I don't have it back.
What's today? Tuesday?
When I know he gets it,
Yeah, so 4 days ago, Judge. It looks like contract was sent 4 days ago to defense. He did pay the DA fee. I just don't have the signed contract back to do the supervision order.
Or the interlock?
The defendant is here today.
You want to check with him to see if he's got the interlock installed? If not, we'll give you a week. If he doesn't have it done in a week, I'm rolling him day for day.
all right.
Because all they said is
Okay.
contract was sent to my last note and then he paid the DA fee.
We'll find out.
Thanks. Are you ready?
Sure.
Hi.
Just on Mr. Roberts, the entry for separate files today, obviously, I don't know.
Yeah, just, I guess, set it 30 to 60 days. Thanks. Hi, Mr. Grant. Hey, what's up?
I have a couple of, but I think only one's on your list. It's Mario Davila.
What is it?
Mario Davila,
The-
it's another gorilla. And he's been approved for PTI. His TRS is set tomorrow, but he's here today.
He's sitting with Mr. Original.
Perfect.
Oh, great.
That's what I was gonna
Okay.
ask for. So-
Yeah, we'll set you 1 to 2 weeks to finish it up.
Okay.
That's all we're waiting for.
Yes. And then I have,
Ready?
Tara Richardson. I don't, we filed the application. I don't know if she's gonna review it.
Oh, Judge, on Leslie's 2 cases, we sent them together.
Yeah, so I said 1 to 2 weeks
So I
to
can
finish it
present them
up.
both then?
Yeah, of course. Okay, you ready?
Yes, sorry, I didn't see you.
Hi.
The person is fair. Fair. F-A-I-R.
Okay,
For that, I'm not gonna do is get for this good weekend. There are no videos on it yet.
okay. It's 190 days old.
What is the last?
There. Jury's here. Ladies and gentlemen, we have a jury here that we're about to bring in. If you're sitting in the middle, please, if you don't mind moving to the sides, we're going to utilize everything for the panel, please.
Oh, sorry.
Is APD judge, so this one like, September baffled, but I know it's from 2021. So I just wanted to double check before I saw the report, and I know we don't have it, and it's not in our.
Okay, I mean, I'll give you till the end of docket.
Yes, Judge.
If it's not, whatever's not in now, it's just not coming in. That's it. Okay, and then I'm going to give you a week to decide what you guys want to do. You're at 190 days old, so he's got to be here in a week to clear trial.
Okay. There's one more conversation. Oh, it says that it is on the stage.
All right.
Judge, for fair, we do have the body worn camera. I'm going to export it to the fence right now. To see if anything have been exported to the fire. We do have that all the body worn camera.
Okay, so regardless, still, you got a week. Can you put offers on it, please?
I think I might already have. Yeah, she already has offers. Chef, in there.
Okay. Hey, Victoria, top of page 7, 1 week clear trial. Yeah. We're going on the record.
And Your Honor, sorry. Your Honor, I'd hate to make this request, but my subpoena for the one officer that I mentioned, the state did subpoena yesterday. My subpoena just came back unexecuted. This is a material witness as a material witness as it gets. I need that officer. I would hate to ask for a continuous, Judge, but I do need that officer.
Judge, she no longer works for Metro PD, and I did inform counsel when we're set for that motion to suppress hearing that they no longer work at the agency. I never received like, I need this person, so we can try to have locate and serve them. So that's the only thing I can say is they don't work for Metro PD. If I would have shown like we wanted this person, we would have had a location our investigators to try to assist him in trying to locate this person, but we were not planning on calling them.
Your Honor, they were.
I mean,
that
this case is, I've got a jury outside.
I understand that, Judge. And I the subpoena will come back, and I also tried to find, I had an investigator that was trying to find her and the other 2 people, but I did let the state know that I needed.
You asked for investigator funds, which I granted.
Yes, to find those other 2 individuals, and I asked my investigator to find her as well.
So tell me, what has the investigator done then?
They have not been able to find out the person. They've been searching for them, but they have not been able to find them.
I understand that.
Yes.
What have they done though? We've given them money to go do work. What have they done in the 3 weeks?
They've been searching. They've been trying to find them.
Where's your investigator now?
They're not here today, Judge.
What's your response?
Judge, the state does not intend to call them as a witness. They've had time to locate this witness. I know they're along with Metro PD, and I did advise that they're no longer with Metro PD to defend, so they were aware of this when we had our first setting. So this is not any news to me. He's still announced ready for trial, so we're ready to go to trial.
And Your Honor, I will say that they did represent that they would subpoena this person and get them to get it. I made that known to you yesterday and the week before. I've tried to find it.
Did you ever, I mean, I don't think that they ever said that they were going to subpoena the person. They've been saying since day one that they don't want the person, that they don't need, or they don't need the person.
That's not true. It's just actually not true, and I was told.
Judge,
just
I
right there
messaged
that
him
they-
on July 27th. I have these officers listed in the office report. Please advise if you have anyone else office wise. And I did inform him, Ms. Jornet was a student and no longer with Metro PD. I did not get any response in regards to that besides the two other real witnesses that are in the accident report. And let me make sure that those are all the names. This is when we're trying to figure out who he needed for the motion to suppress and for the motion for speedy trial. And at no point did I indicate I try to locate these people or anything like that. I believe that's what he got investigators funds to try to find this person. We did not intend to call them. We intend to go forward with trials with the witnesses that we have. He's been pushing for the speedy trial for it to go.
What is this witness going to testify to?
This witness is going to be able to testify to the will witnesses' statements to her. She is the main officer. There are other officers that spoke to the will witness, but she is the main one that asked and questioned them about operation, Judge. And she's as material as it gets.
Is she going to testify differently as to what?
It's not hearsay, it's present sense impression. And there's other.
But do you have a will witness as well?
We spoke to the will witness judge in regards to coming to testify. So they're going to subpoena to come to testify.
Is it a civilian or is it an officer? And are they coming?
They have not confirmed with me that they will come. Not one of them never answered my phone calls. The
Be
other.
careful what you wish for, Mr. Burnett.
I would like them to
Be
come.
careful what you wish for in this life.
I would absolutely, and Your Honor, I had not been provided with that information, but I would ask that we send somebody out. I would ask that somebody go bring them in. I would ask that we send.
What do you
somebody-
mean, someone to bring?
I
Who
would
in?
ask that we send an officer to go and attach them to this case and bring.
You don't have a duly executed subpoena to attach a witness
I
to.
actually do have a subpoena for those.
Okay,
Judge.
okay. You don't have a subpoena that's been executed to attach.
Not executed, yes. Judge,
Right.
but, got it.
For the two real witnesses, I do, but not for the office.
Well, if she's got them.
How
she's got
long of a
them
reset do you want?
As long as it takes to go and attach them and bring them here.
You first need to have a subpoena.
She says she has a duly executed subpoena for those will witnesses. Judge.
Let me double check.
That's what she just said.
Judge, in regards to the will witness, I'll work on with our investigators to try to get them to come and speak to them to make sure they understand they have a subpoena and they have to be here. There was one that did not respond, so we're not sure if we have the correct information for that one. We know that it was executed, but we don't know if that person still lives at the location because we went based on the information that we had in the office report.
If this person has moved out of state, it's moot.
Correct. So that's what we can't confirm, Judge, in regards
You
to
know?
the second will
But
witness.
we can't decide that they have just without checking.
How soon can your investigator look into see?
They're running the panel now, and then I can have them do that, switch from the panel to that. And I can have other investigators in our office focus on that, Judge, if you allow me give me 10 minutes to call.
Yeah,
maybe a little
okay.
less.
Stand down 10 minutes. Let's see where they are.
Yes, Judge.
Because if they're out of state, then we'll just go forward. You
Yes,
know,
Judge.
if they're, local,
Yeah.
then we'll cross that bridge when we get there, I guess.
Yes, Judge.
All right, let's stand down 10 minutes. Okay, thank you for being patient. You ready? Okay.
The next one is Mr. Lee.
Okay,
So for him, he's in terms of the PTI contract, he's done a TRAS, paid the DAP, he has a device. He said that he dropped off the contract to our office on Friday.
where is he now?
He's here.
Okay, Mr. Lee, come up. If he doesn't have the contract here, I'm gonna roll him until tomorrow. Your case is 220 days old and all he needs to do is get the contract, so we can just roll it.
Contract was received August 18th.
Oh, the contract was already.
Yes, yes.
Oh, yeah, we called it. He informed me that he dropped it off on Friday, but I wasn't there on Friday. Nobody has given it to me, so I need to.
You want to call them to see if they have it? Maybe they can get it to you now and they can. Or do you want to roll till tomorrow?
I think both of them.
Okay, roll till tomorrow.
Judge, I am gonna ask for admonishment just because I'm looking at it as a note from Carolina and Tate prosecutors. Just that indicated the defendant was pulled over on 8/19 with a handgun in his vehicle and violated his bond finished. So I would just ask for an admonishment since he was entering the DWI PTI. I don't.
Do we know?
He wasn't charged or anything like that. It's just what intake had informed me in regards to him having a firearm in his.
You have bond conditions, Mr. Lee. Excuse me. If you violate these conditions, I'm going to throw your butt in jail and everything that you've worked for now will be for naught. Have seen more denials of the PTI program because people have bond violations than ever before. Do you understand? Take a seat for me. We'll roll to tomorrow, please. Okay. I just keep me in the loop if you.
Yes, Judge. They didn't file any additional charges. They just indicated they got a call. So that's why I just wanted to be admonished. It would have been.
Yeah, I think.
Sometimes.
It's 220 days old. Do you have anyone else?
Yes, Mr. Nguyen in.
Nguyen. Okay.
For him, he submitted his,
Mitigation.
yes.
Okay. Any word?
I don't.
No, I haven't gotten it yet.
Okay.
To us, Thursday or Friday.
It's 160 days. I'll set you a week again. He's got to be here. Is he here now?
Yes,
Okay. Do you guys have the mitigation packet?
yes, he said today.
Okay, great. So we'll give you a week and then I guess we'll go from there.
The next one is Mr. Simon.
Okay.
For that one,
Is Mr. Simon here now?
no.
Also a week to do it to your ass for Mr. Simon, bottom of 20.
Judge, you know, those food is not vaccine or point of this food, so it's gonna be a 1 year PTI approval, so you can get a TS.
Are you approving it?
Yes, Judge.
Okay, great. So we'll set you off also a week. He's got to be here to get the TRS done.
Yes, sir. Last one is Mr. Valdez. I did not check it with the clerk yet, but it's a motion to withdraw. We came in before, I think the day you
Well,
were.
let me see how old it is. If it's old, I'm not going to grant it.
Okay.
It's 190 days old. I'm not granting your motion to withdraw.
Okay.
Is Mr. Valdez here?
He is.
Mr. Valdez, come up.
He's an interpreter.
Okay, just give me a second. We'll get an interpreter then. Does he have the application done?
No, he doesn't.
Okay, he's been working on it since for about 3 weeks. We'll also roll him to tomorrow to get the application done. And we'll go from there. Okay. And let him know that if he doesn't have the application done, he'll come back Wednesday, Thursday, Friday, and then.
Yeah, just trying to. Thank you.
Thank you. Hi, it's, hey,
Judge, I have Silva on the docket, Angela Silva.
okay.
She picked up a new stuff from Judge.
Yeah, I saw that.
Yes.
I'm gonna revoke both of these bonds. And Silva. So she's on bond with us for, first she picks up a mischief, then she picks up a theft, now she's picked up a UMV. I'm gonna send them both at 5,003
Each
on
one.
our cases. Yeah,
Okay.
each at 5,003, and then we'll see if she bonds out.
Same bond conditions?
Same bond conditions.
Thank you.
Yeah, yes, ma'am. Thanks. Hi. Ralph.
I got Mr. Bible, he's complied with everything, Judge. Judge, he beats the eye.
So are you ready to file the supervision order?
I do what you ready. He's got the fee paid, the interlock, the terrace completed, and the application.
What's the contract?
Sorry, here.
That's not the contract. Contract's
That's it.
Oh.
See? Yeah, that is-
Yeah, I know that. Yeah, communication. And then. Okay, defense needs to sign, Judge, and then he has to swear with the clerks, and then we can get this done today.
Wonderful.
Okay.
He needs to sign it, swear to it, and then we're
I got
good.
lucky, Judge.
Go play the lottery.
I think I got lucky.
Go play the lottery, Ralph. Are you ready? Thank you.
I don't know how it all came together, but it did.
It did? Hey, that's okay. Are you ready?
Yes.
Thank you for being patient.
I have the knowledge.
Oh, I'm sorry. We've been so preoccupied. I'll sign it right now.
Yeah, that's for Mr. Kirkpatrick.
Okay, I'm signing it right now.
Thank you.
Thank you for being patient.
My
Okay.
pleasure.
Hi. Craig, you ready?
Yes, sir.
Hi,
Good morning, Your Honor.
good morning.
So Mr. Pansky's husband, posted bond for, but I believe she's still in custody at this point. Right?
Okay.
She was on docket today.
They always roll it to the next day as a fail safe. So,
Yes, sir.
um,
So as soon as she gets out, I'll
Hey.
have her.
no. So she needs a, GPS prior to release
She has the conditions.
and then home confinement. Okay?
Yes, sir.
Yep. All right. Thanks. You got it.
What, however soon we can get one is fine.
I would do it, yeah, ASAP.
If we can
Yeah.
get one, I'll speak. to her.
And then obviously, hey, Veronica, she can leave for purposes of the TRAS, then she's got to go right back home. Okay? Okay. Thanks.
Thank you.
Omar, hi. Thank you for being patient.
The case that I put on yesterday, so I get attached to, I was never attached.
I don't even remember you coming yesterday.
No, I zoomed in.
Oh, that,
and it
that's
said-
biggest.
I don't even remember. Did you zoom in yesterday?
No, it wasn't yesterday, it was last week. I zoomed in and he said, put the cause number in the chat. I heard you tell the clerk to.
It must have been an oversight. I'm sorry. We've got a lot of drama that goes around here, man. I'm so sorry. I will attach you right now.
Some others.
Okay.
No, tell them no.
Do you want to let them know and then they'll put it in the queue now,
Yes,
please? Sorry about that.
no problem. Yes, please.
Okay, what's the call?
246.
Hi. Yes, of course. Hi, good morning, Ms. Rowell.
I'm gonna be really quick. Your Honor, I've got a trial case on docket for Tuesday. I have a cause number if you need it, but just want to give you a heads up. It's 25968.
25968.
I'm sorry, 2596856. It's Guillermo.
Gonzalez, okay?
Yes, that's right. Yeah, I'm starting trial on Monday in the 180th. I just want to give the court a heads up. I didn't know where you're.
We'll hold it. If you're in trial, obviously we'll reset it and we'll go from there. Yeah. Because some, a lot of times your cases up there don't even
That's
go,
right. That's right.
whatever happens, but.
Well, I'd rather be here than. No.
All right, great to see you, Mr. Vale. Hi, Connor.
Okay.
Oh, hold on. Kobe's been waiting. You just got here. Kobe.
Hi, Jim.
Can you hear me?
Yes, I can hear you. You can hear me.
Shh. Okay. Who you got, buddy?
I have Miss Granberry, who she had a bond violation report related to the. She's the one who's living in Memphis, who was ordered to go to drug testing.
Is this from yesterday, right?
No, that was we had a lady that was on dock yesterday. We dealt with that.
That's someone else.
Yeah, so Miss Granberry, she's not showing up on my docket today, but you had ordered it to be put on the docket, and they had ordered her to be here, and
I
I think,
don't see it either.
yeah, I think she's there.
It was ordered via email. I'm not sure if it was placed on the docket.
What is the cause number, please?
It is 261-9676. And she did test this morning and tested negative.
So Judge, if you remember, this is the one I'd emailed you. I had sent her to get a rapid test somewhere, and so we'd sent you the results kind of the day or day after she'd been ordered to do it. I guess we probably hadn't communicated well enough with the court that she was in Memphis, so it hadn't been set up for her to be told to go to whatever the testing out of town was.
I didn't even see the bond violation report filed electronically.
She did not get a violation because she's on a summons and not a bond.
But she has 4 other bonds. She's got 1, 2, 3, 4, 5 open cases. They can't do it on the other 4 that are open? Please, that would be great because, paper for everything, publish or perish, So from now on, please, because you can see the kind of snafu and the kind of problem it creates. Okay, we'll continue supervision for now, Cobe.
Okay, thank you. And I think the state had been, we had just had a court setting, so they had been doing an eval to try to figure out where we were headed
Okay,
with all this.
do you want to
So
keep the 9/3 date?
we'll keep that date. Yes. Judge.
Okay, all right. This is a Granberry.
Yes,
Okay.
Judge.
Yeah, she tested negative today, so we'll continue supervision.
No, sorry,
And then we'll just keep the original date of 9/3.
okay, just to have to.
Okay, it'll be waived.
Yes.
Okay. Okay, bud.
Thank you.
Thanks.
Thank you, Judge. Yes, sir.
Have fun.
Do you want to amend the conditions to allow her to test on the months?
Yeah, that's okay.
Thank you.
Yeah, but on the other 4 cases, please. Okay. Connor.
Hi, Judge.
Hey,
Yesterday on a case,
I remember.
she's here today.
Oh, is that the arraignment, Victoria?
I don't think so. It's
Nope.
Gomez Lopez.
That's not you?
I don't believe so.
Okay, what's your cause number?
It is, so the case that is open right now is 262-8144. Maureen Jordan.
Okay, can you give me 2 minutes? Just give me 2 minutes. I need a call.
Alvarez. Doesn't need to be going through, which is. Okay. Did you find that motion?
Because I've got 3 different ones. Which is, it doesn't show up. What's the last 4 of that one? Okay, got it. Okay, let me step up.
I mean, I was a four.
This one was much more self-sufficient. The first one, the case for it. They were. I sort of plan. I don't know. It's actually. It doesn't matter. I think you that the same event, like I don't know. I got why is there 80 cases?
It's just
But I can share my.
All right, so there you go. All right.
Yeah.
Cowboy.
No, yes.
Just need to know.
That's all.
Okay. So for snow, it's again, even on the state says discoveries and then we get first part project. So you might have
Are you ready?
Every time we go to the family, we have to have a
Right. Okay. Certainly.
Coming back first.
That's assuming that she's flying.
Okay.
Okay, got it. Thanks. Okay, bye. Okay, Connor, sorry.
No problem.
Any luck? Michelle, any luck on the witness?
Yes, so, one of the witnesses.
No, not his.
Yes, both of them. Should I talk to them first?
Council, you ready?
So I called both, I was able to get in touch with both of them. One said that, he'll be able to come, but he can't be on call.
Who is that one? Your witness,
The wheel witnesses.
right? But I'm more concerned about his witness.
Both of them
If the
would
real
technically
witness I'm looking to get their statements in. I was gonna try to bring it in through the officer, so if they can come, that's even better.
But what if they don't?
I would like them to come, and if she has a duly.
You know how that
attached-
works? I want hair. I'm not gonna get it.
I understand, but if she has a duly.
Point out that she has requested a speedy trial and has waived all notices and has waived everything in regards to subpoena stuff. And we have been bending backwards to make sure that we're ready for trial. So he's making demands. We looked at the subpoenas for the wheel witnesses. They weren't executed, unfortunately, because of the short time that this was set. So we contacted them. We're gonna try to get them here and do our due diligence to try to get them here because that is our job. But him making demands to attach someone that wasn't properly subpoenaed is improper, and, you know, he needs to understand
The
that.
state,
We have a duty and we're trying to comply
and
with our
the,
duty,
and the
but our,
state told me that they just said. up
Do
here
you
that it
still
was
want a
was
continuance? Yes
I
or
would
no?
like it if I can be able to either get them here or to be able to get them, and
But there's no guarantees in this line.
I understand there's no guarantee, but first of all, I do think this witness was a person in a car crash. There should have been a rip call.
So,
This was
well,
discoverable
Mr. Burnett,
information.
Do you just want a continuance? If you
Yes,
want a
Judge.
continuance, I'm giving you 14 days,
Yes, Judge.
but that's the last continuance.
I
You will be
understand that.
prepped set for 2 weeks from today.
Can we ask for this information to be released to us because it is discoverable?
do you wanna go on the record, Joe?
And I'm not here in 14 days, I'm in a seminar.
When are you gone?
I'm going the 9th through the 11th. I'm in a seminar.
Okay, so I guess let's do the 15th. Okay? I need you to file a motion for continuance.
Judge, one.
You said the 15th.
You hold on.
Judge,
Guys, we are going on the record. I'll let you make your argument. We're back on the record in cause number 2610088. Defense has subpoenaed a witness, asked for funds, which I granted on 8/13. We're set for trial today. I've got a jury out there waiting. And he's just come up to say that the subpoena came back unexecuted. He is saying that this is a material witness for the defense and that he initially asked for continuance. State, what's your position?
Judge, we will be opposed to the motion for continuance. Defense has requested a speedy trial. We have been able to contact the real witnesses, which is the statements that he wants to get into during the trial. One of the witnesses just needs to confirm with work and can make arrangements to be here this week for trial. The other one says they will be available to come and testify on Friday for trial. So we're trying to coordinate their schedule. If the court would like to coordinate with their schedule, if we're able to, then we would ask to go forward and we're opposed to the motion for continuance. I will like for the record to note that their subpoenas were not executed due to how quickly the trial was set.
First, on the issue of the material witness, this person has exculpatory evidence from my client that is
Your witness.
my witness, yes, and I believe the will witness as well, because it was their statement that I was going to attempt to bring it to them because my investigator had not been able to find the will witnesses. I went to their addresses myself personally before I even asked for the investigator or the addresses that were on their licenses at the time. On top of that, Your Honor, I would just say I believe that these will witnesses who were part of a crash, who technically would have been victims, any conversations should have been discoverable and should have been released to the defense, phone numbers, things like that, so we could have actually prepared for them to be here. We're never informed that they were able to make contact with them. We did ask the state to subpoena all witnesses. They told me that my witness, Janae, did not work at the Metro HPD in the email. Did not say that they would not subpoena her or try to get her here. And that is the reason why my subpoena in a short time was not able to get executed. But I was under the impression that the state was going to subpoena everyone. So that is the reason why our subpoena was late in time, because we noticed they had not done as they had told us they would.
Do you want the continuance? Yes.
Judge, but I needed to make the record clear. But
Yeah. I get it.
we would
I
like
will.
the continuance, and we would ask that those RIP calls and that information be shared with us, so that way we can try to ensure that these witnesses can be here and schedule a time.
What's your response as, not for the continuance, but what else he's asking for?
In regards to the recall, Judge, we will disclose any conversation we have had. The third's duty is to disclose any Brady information. The phone numbers for these witnesses were in the office report and the information that he has had. throughout the trial. He also has subpoena power to subpoena these witnesses if he believes that they are material to his defense.
So everything that he's saying is in the offense report.
Yes.
Your Honor, I've called both of those phone numbers that are in the offense report. One was, the phone was off and the other one.
Well, but they don't have a duty to continue to look for phone numbers. I mean, whatever's in their possession is okay.
And that's the
Yes,
phone
and I'm
number
not sure that they're using the same number.
That's the phone number we reached them at.
Okay, I need you to file a motion for continuance. I'm gonna grant it. You will be preferentially set on the 15th of next month. We are going, regardless, it doesn't matter. I would probably get the subpoena out now
Yes, sir.
so that there are no issues in the future, but there will be no final continuance in this case.
Yes, sir.
Judge, in preparation for this, I have contacted most of the witnesses. I'm gonna double check the emails in regards to any conflicts they may have asked. I can inform the court that.
Okay, well, I mean, that's a good idea.
Yes,
So
because I did contact them for all of September to see if they had any conflicts. So I'm gonna go through my emails and I will advise the court and the defense by the end of the day if there were any conflicts.
why don't we regroup tomorrow morning?
Yes,
So that we can finalize the actual date to make sure that your witnesses are good and then get your subpoenas out, but this is it.
Yes, sir.
There will be no final. Okay,
yes, sir.
all right, anything else?
That's it.
Okay, do you mind releasing the panel, please? And, Mr. Burnett, I need you to file a motion to continue a second grant. Please. Okay, cut it loose, please. Hi, Connor, you ready? All right. Marnie Jordan, come up. Oh, I'm sorry, Blossom, I just saw you. Do you need a translator?
No.
Okay, Blossom, I'll hit you up next. Sorry. You were, Miss Jordan.
You need someone to sign when you have a seat. He has several tissues that need to have to come up to sign. Not his signature. All right, go ahead and sign. Go ahead and slide over.
We're pushing up
Yeah. All right, Miss Jordan, so she's on bond for a theft.
Yes.
On 7/30, she picks up an organized retail theft, which is discharged,
Yes.
and now she's picked up another case. Now you're charged with false report to police officer.
Yes.
Right. On that case, ma'am, you are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. False report.
Yes, sir, I have here. Officers, the defendant reported that on August 15, 2026, her rental vehicle had been struck by an unknown vehicle in the E. Terry's parking lot located in Bridgeland, Harris County, Texas. Initially, she provided deputies with a statement claiming that an unknown dark colored SUV backed into her vehicle and left the scene without stopping. The defendant stated that she was not at fault for the collision and wished to pursue the charges against the unknown driver. On August 16, 2026, the defendant contacted dispatch and requested to speak with the deputy in regards to a subsequent telephone interview with that deputy. The defendant admitted that her initial statements were untruthful. The defendant stated that she initially provided false statements because she did not want to be found at fault for the collision. The defendant admitted that the collision actually occurred while she was traveling behind an unknown vehicle, which was stopped at the stop sign located within the P. Terry's parking lot. The defendant stated that she struck the rear of the unknown vehicle, causing the damage to both of the vehicles. And she admitted that she was at fault for the collision and had falsely reported that the unknown vehicle had struck her. He said she was scared and didn't know how to handle the situation.
Does Miss Jordan have a license to drive?
She's valid.
Now, just to make sure.
Let's make
So that it is
sure.
eligible, and yes, that's fine.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. I'm ordering you not to have any contact with the complaining witness in this case. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you violate these conditions, I will revoke your bond and put you in jail. Do you understand? Okay. Now, she's on bond for a case. She's now picked up a new case. What should we do on bond? Are you here with a bonding company?
There is a bondsman here, yes, sir.
What's your position?
Your Honor, considering that this is the second new law violation that she has picked up law out on bond, state would ask, to go for bond and to judge it.
So Judge, a couple things, the organized retail theft was no PC and it also included partially this underlying theft, so it.
What do you mean partially?
Because as a part of the allegation included the theft itself. So was going to say like this theft from here, theft from here, theft from here was the aggregate. But that was no PC. And then also, and I know this doesn't go to PC, but she did make the report, or she said she made the report, and then she called the officer, tried to right her wrong. She showed up here today on her own volition.
I appreciate that. So, but I nevertheless, she picked up a new case.
Yep.
So what I'm going to do is I'm going to set both of your bonds at 2501, but I'll allow her to go with a bonding company now because she came in.
Yes, sir.
Ma'am, if you pick up a third case, I'm going to go bananas on your bond. Do you understand me? There's no excuse. There's no more tolerance after today. Do not pick up any new cases. Where are the thefts from Walmart or
HEB, Judge.
both?
Yes, judges.
You were not allowed to go to any HEB whatsoever for any reason. Do you understand? Let me see if we have bond conditions on that.
We do, Judge. No HEB. I think the biggest.
Yes, Judge,
Yeah.
there's no HEB.
Okay, all right. So what I'm going to have you do is I'm going to have you take a seat in the jury box. We will have bond conditions created for you to sign. Once you sign and the bonding company is here, then we will release you today.
And Judge, for the bond conditions on this new case, you just mentioned no contact with complaining witness. I don't know that we have a name for
That's
it.
correct. I was gonna say, Judge, we have the complaint.
So there's no accident. It was just
There was
a,
an accident, Judge, but there was no accident report ever done because they didn't know the name of the other driver in the vehicle. So there was no listed info. So just been no driving without an object.
in insurance then. Yeah, yeah. Okay. All right. Thanks.
Thank you, Judge.
So don't worry about getting a setting
Okay.
because once she posts bond, she'll get a 7-day setting and then you feel free to reach out to Victoria and then we'll,
Sounds good to me, Judge.
okay.
Cool.
Thanks.
Thank you.
Here for the off docket.
Okay. Sorry, guys. Let me just do this. All right.
Lopez, Gomez.
On both of our cases.
2501 and I'm looking at
Okay.
keep the old one the same.
No, both of them are 25. The new case and the false report and the theft. The organized retail, it's, no, there's no PC. So it's, what was the last name?
Lopez Gomez.
Is it on docket or not?
Off docket. Is it off docket?
Is it off docket?
Yes, Judge, I have the case number. You ready?
Yeah, yeah.
263646.
All right. You are Miss Lopez Gomez.
Yes.
Ma'am, you were charged with assault causing bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Officers were dispatched to Houston Thompson Hotel in Harris County, Texas, in reference to an assault that just occurred. Officers met with the complainant, who indicated that she is a supervisor of that location When the defendant arrived at the lobby, she was detained when the officers met with her. Complainant stated that she was alerted by staff that the defendant was on the 7th floor bar, highly intoxicated and causing a disturbance. Several staff members went to address the defendant and tried to escort her to her room. Initially, the defendant had gone to her room with the staff, but then became hostile and returned back to the pool area. Complainant has stated that she had tried speaking with the defendant again, but the defendant became aggravated and slapped her twice in the face on the right side with an open hand, causing pain, and that she was to press charges.
Ms. Lopez Gomez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. There will be no more PR bonds for you. You understand? I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they may very well put a detainer on you and you could be stuck in custody for a very long time. You are not to have any contact with this complaining witness, not to go back to this hotel, and not to be in possession of any weapons. Do you understand?
Yes.
Do you have a lawyer, ma'am?
No.
Do you have the ability to hire a lawyer?
Yes.
We will give you time. I'm going to have you go sign a reset. We will have you meet with Veronica for your bond conditions, and after that, you'll be free to go. We will see you back in 30 days. When you come back, please have a lawyer.
If I can't return because I don't live here.
You have to return. If you fail to return, I will issue a warrant for your arrest. You have a criminal case. Your presence is required until you have a lawyer. At that point, we can discuss about waiving appearances, but at some point you may need to be back. Until you have a lawyer, your presence is required here.
Okay.
Okay, thanks.
She did say that she was going back to Mexico, so for the random testing, did you still want to look?
I'm ordering her. I'm ordering you not to go back to Mexico at this time. You have an open case. If you go back, I will issue a warrant for your arrest. So let's do this. You need to first talk to a lawyer and then we can go from there. But if you go back and you don't return here, I will issue a warrant for your arrest.
Can I go on that?
That's,
Yes, please.
I cannot give you legal advice. You need to talk to a lawyer about that. A lawyer can give you legal advice. I'm just warning you, you were on bond for a criminal case. For the time being, your presence is required back within the next 30 days. If you fail to return when you're supposed to, like on the reset, then we will issue a warrant for your arrest. Okay? All right. You are required to undergo bond conditions and testing. If you fail to live up to the conditions that we have set, then likewise, a warrant may issue for your arrest. You are required to periodically come and do drug and alcohol testing. If you fail to show up on the day that you're required, a warrant may also issue.
But I don't understand.
Then talk to a lawyer. A lawyer can help you out.
Okay.
Please.
This way.
Thank you for being patient. Yes, Ms. Cook, come on.
It's all right, my need to zealously advocate just.
That's okay, really. I wouldn't expect anything less.
Conceiving with it.
Yes. We need someone brought out.
Regarding Tyrone Joseph Jr., he's off docket reset for today.
Okay.
The state is asking for an extension. We talked to South Carolina. They're unable to pick him up until 9:15.
Defense is opposed to this.
No, I'm with you. I'm not, no, that's, how fair is that? Imagine if you were in custody waiting and someone,
I
really?
understand, Judge. Here's the problem. We have talked and defense is not sure on whether the defendant is able to make a bond and get himself back to South Carolina to self-surrender.
That's, I mean, if they don't come within the prescribed time, I'm gonna give them a PR bond. And will be directed to go back.
The number is one thing, but because they're fugitives, the PR bond I would object to because they're still statutorily fugitives. And so if the court decides to give them a low bond, obviously that's a separate issue, but he has extensive criminal history. And so whatever is persuasive enough to surrender, that I would object to.
Why couldn't South Carolina come to pick them up within the time prescribed?
Because with their means and resources, they can come within the 15 days, but they are emphasizing the 30 days statutory by law that they are allowed to do so. And so with the withdrawal waiver, if they can't make the bond, that's one thing. And we have up to 90 days to get the governor's warrant while he's sick. But that's why we're approaching it the way we are.
What's your cost number? Please.
263-5635.
So it's a failure to return rent, fraudulent application of $10,000 or more.
I believe it's the equivalent of a stolen car, but I had to refresh the case file.
Fraudulent appropriation, is that auto? I can't even read that. What does that
It was
say?
another 10,000. The way to categorize the thefts are different from our ladder, but it's, I think, if I'm recalling the conversation correctly, it's for a stolen car.
Shh.
So, right.
Yeah, I think that holding him that long is.
Well, and like I said, if the court elects to give him a low statutory bond, that's one thing. Whatever number the court elects is reasonable for him to self-surrender. But obviously, even if, let's just assume it's $1. Even if it's $1, he doesn't have the financial means to self-surrender. He's still under bond. A warrant's gonna be issued out for his arrest and he's gonna come right back here, which is why we approached the way we did. If counsel believes that there is no number that can be listed where he can actually go back to South Carolina, then it would be in his financial and otherwise interest to keep it until the 15th to get a free right back because the warrant's still good there.
Let's
I
see.
think that we tell people when they're arrested on federal court, what they sign that waiver, what they're signing. And, it's very confusing for them. And if we start waffling around like this, people just don't.
I'm on your side. I agree with you. So what do you want?
So I'd ask for a PR bond.
And like I
And
said,
then the alternative, I'd ask for
Can you,
a $5
can you,
surety bond.
can you direct me to a place that says I can't give him a PR bond?
I will bring the code for the next story. He's not here today. And so obviously the other factors is I would want his means to actually self-surrender. Because again, even if it's $1, even if it's a PR bond, which I don't believe is statutorily permitted.
When is he set?
He's set for, well, he was set for a day, he just wasn't brought up. He's not in the holdover. So
Do we have too many people? Do you know why? Don't worry. I mean, it's just neither here nor
and
there.
so he still would,
You want to roll it till tomorrow?
that's fine.
Are you okay
But
with that? Can you be here?
I can be here tomorrow, but we also just want to give a PR bond, or we get you a $5 bond. I have contact information for his family. I'm confident I'd be able to get a hold of them.
But regardless, I'm not going to set a bond till he's here so I can admonish him.
That's true.
And
So if you want to roll to tomorrow, I'll take it under advisement, but also show me why I can't give him a PR bond.
I will look it up, but that's only half of it. Like I said, even if it was 0, right? He still has to have the means to self-surrender and the warrant is still live. So if he gets arrested.
Let me ask you something. Are these new cases?
No, this is an FTA, Joe. I believe it's an FTA. Yeah, failure to return. Oh, wait, no, hold on, sorry. I don't want to misspeak. I don't have the underline.
They're not new?
The warrants from 2025.
Yeah, it's been live.
Do you know when from 2025? Oh, okay. It doesn't matter. Dude's on probation for a couple cases upstairs
Right,
regardless.
that's what I meant,
So
because he has significant history here, and so obviously the concern, he's not the best at returning or picking up new offenses while he's on current.
well, but I understand. And if we set him a bond and he fails to do it, there's a consequence.
Well, I think he's already had that multiple times in Harris County, which his record shows in Harris County. He's had that opportunity multiple times for other cases, but that's beside the point. Again, My emphasis is on feasibility.
I didn't see any prior out-of-state fugitive cases.
No, I'm talking about the cases that he was on bond for picking up new cases and violating.
That's up to the felon court to deal with that, man, not.
No, Judge, that's not my point. Your argument on that was that for his compliance with your conditions, assuming that he's admonished tomorrow and he's self-surrendered. My point was that he has been admonished several times on other offenses. He's not great at complying with court orders. That was my point.
And I'll admonish him as such tomorrow.
I will bring up the statute and,
Okay.
and also ask questions
Thanks.
permitting the.
Nothing further.
Okay, thanks.
See you tomorrow.
See you
Thank
tomorrow.
Judge.
Yes, ma'am.
8:26.
Hi, Sebastian.
Maybe.
Are,
I have Castro on the docket,
are you, what about Velasquez?
That's one.
Okay,
Sorry, Velasquez Castro.
got it, okay.
So he has had a DWI, picked up a second one. He has an ice hold now, so that's.
Okay, I guess we'll just wait to see, if you want to set it a week, 2 weeks.
I can ask for 2 weeks just so I can.
Sure,
Of
course.
Get him on them.
Yeah, okay. Thanks.
Mr. Bell, that's the one that you did not, unless you took the job. We have to, translate that right now.
Okay. Blasa, can I borrow you for a second?
Did speak to the client, he's saying that he doesn't recall anything about.
I don't care. He could tell me he's with the circus. I mean, really, at some point,
But there's.
Mr. Bellix.
There's also a language barrier, so I usually have to have somebody in the office communicate. And
Your case is 190 days old. This could have been done way long ago. Mr. Valdez, shh. Just to give you a little perspective, we set cases for trial at 180 days. We cannot keep cases open forever because our dockets balloon out of control. We would have hundreds of people on the docket. Your case is 190 days old. It is time to decide what you want to do. So I will give you until Monday. What is today? Tuesday? Monday to decide what you want to do. If you want, you must at that time either accept or reject the plea bargain agreement from the district attorneys. If you want to apply for the intervention program, then everything must be submitted by Monday morning. If it is not, then you must accept or I will set your case for trial. Do you understand? You will get no more resets after Monday. Anything further?
Sorry to pay what I owe.
I'm going to let you discuss that with your lawyer. It's probably a good idea to bring someone who speaks English to help facilitate the conversation. But at 100 and now over 200 days, when you come back, I'm not going to give you any resets. It is your guys' responsibility to find someone to translate. In the interim, if there are possible immigration issues, it is on you to go between now and Monday to talk to an immigration lawyer. I will not give you any more resets. The next setting is trial. Do you understand?
Yes.
See you Monday.
Oh, I'm citizen.
Okay, I'm
Sorry.
out of an abundance of caution, I'm saying it to everyone.
There's one more judge.
Is it fair? I'm gonna wet myself. Okay, who's next?
The last one is Mr. Lee.
Lee.
Earlier on. Here.
Yes.
He was reset for tomorrow. That's the one about the contract.
Okay.
I do highly anticipate that it'll be submitted today, but I know he was rolled to tomorrow. But he did let me know about a trip he already has his.
I don't care. This should have been done a long time ago. I want to make sure that it gets filed. If you can file it now and they can file the supervision order, then we're good for tomorrow. But I'm not, no, it's 220 days old. At some point, we got to put it on.
I mean, everything more than it's.
Hi, Brent. How are you? Happy Tuesday? I don't even know anymore. How are you? Great to see you. What's new?
Just got a crazy day. I've got.
How can we help you?
I've got a case.
Okay.
Everything's good with you?
Great, no complaints, you know, just drama here and there, but I mean, that's what we do, right? I can't complain.
I just saw a lot right now. And you know, my new thing, I got this thing now where when I see people, instead of saying hello, good day, or, you know, I ask, tell me something good.
Yeah, that's nice.
Because we deal with so much negative stuff that I think it's important that we don't lose track of the good things that we have going on in our lives.
A positive attitude can have such a great impact on everyone and just, and sometimes it's just really hard, so it's nice to really step back and just take a breather and,
I look at some child porn on Monday morning and I'm like, I gotta do some, I need to get some positive things in there.
And it seems now with the AI, I mean, it's just like, whoosh.
Yeah, it sounds like they've been a big bust on some.
Yeah, I saw
some
that.
law enforcement officers or something like that. So,
No, multiple.
Oh, yeah.
So, yeah, those cases are always a doozy, man. I mean, and back in the days, I had a couple and they're just really, really tough. Just the DA's office, I don't know if they still have an office policy here or whatnot, but anyways, just think positive, my friend.
I'd like to focus on the good stuff.
Yep.
So I'm gonna go
have fun. Great to see you though. Did I ever fucking? Okay, the 2 jail cases, the 1 jail. So is there anyone else? Do I need to do daily? That's right. Okay, I'll do that now. Yeah, I got it here. 263. Veronica, can I trouble you on Miss Jordan's case? Do you need the cause number? Just on the new one, I need a PSR, please. Its cause number is 263-5558. I don't, or let me, you know what? Yeah, I mean, let me, if you don't mind, let me have one just in case, please.
So the other 4 cases got permissions from the different JLOs. Random testing on those. She had random testing.
Can I go ahead? Can we go ahead and put them on? Yeah, and then I'll waive the signature if she's not here.
She's.
Oh, wonderful. Okay, great. Thanks. Hi.
Good morning.
Hi, Miss Brenda. Come on up. Good morning.
How are you?
I'm doing great. You?
Good.
Yeah.
I'm Mr. Ramirez.
Ramirez. Jail or bond? Okay.
And he has an MHA that's been filed. I talked to the state, if he is able to pay his fees, because I believe he was on probation for 18 months.
This counts, the case is 2,386 days.
So
Where is he now?
He's here.
Does he have bond conditions?
I believe so.
Let's see, because I don't remember Mr. Ramirez.
He just got served with the MHA, but I believe we have a resolution for what he's trying to see if he's something's going to be okay with it.
He really didn't do much of anything. He didn't do anything.
I think I signed an attorney when we were out and they reset the case and such a way.
So he didn't get bond conditions? Or is there any restitution that's owed?
On mine, it just says he, again, this is what I probably said, that he completed just checking the last 3 months, because that's what he had moved to.
Oh, no. So he failed to get an interlock, tested positive for meth.
Oh, I don't have it.
There's no.
Huh?
There's no restitution.
Okay. Yeah, he's looking at 45.
Okay, well, is there a way I can get a copy of the one you have? 'Cause this one,
Here, I'll print it out for you.
okay.
It'll be next to Victoria.
Oh, wait.
You said we're mirrors.
Yeah, that's right. It's for Miss Miranda. Christie. Hey, I printed it out for you.
Thank you, Judge.
So if you want to take a week or two, but he needs bond conditions. So he needs a portable device. Hey, Victoria, do you speak Spanish?
English.
You don't speak Spanish?
Oh.
Does he speak English?
He speaks English.
Okay. Ramirez, come up. Does Mr. Ramirez have a valid license, please?
I don't see a driver's license number.
Mr. Ramirez, you speak English? You are not allowed to drive. You do not have a Texas driver license, and I'm going to have you sign an affidavit. I really don't care what you have to do in this life. You have now, they have filed a motion to revoke the probation. We have one of two ways. You can either accept the agreement, or I will set your case for a hearing and you will be looking at a year in jail. You are not to consume alcohol or illegal drugs, and you will get a portable device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. You have 2 weeks to be back. At that point, if you're not ready to accept, then we will have a hearing on your motion to revoke. You understand?
Yes, sir.
Okay, all right. See you in 2 weeks. All right. Hey, so remind me, 45. Hi, Sebastian.
Approach on an agent before Castro on page 31. I'm okay. The license Castro.
I think that's how we have it, right?
Victoria told me that there was something, that it was Castro, or one of them was.
Okay, I'm okay with it. Sure. Yeah, for sure. Hi. My allergies are killing me.
Smith, we have the.
Okay.
Queue.
I'll sign it right now. Got it. Okay, I'm signing it. Hi, Mr. Weeks, come on up.
I just filed a motion a few months ago. It's a motion to be appointed as second chair.
Okay.
I know I asked you earlier, but I wanted to.
I'm okay with it. Yeah, for sure. Did he file a motion for continuance yet?
I'm not sure.
No motion for.
I can call Judge. It's on my motion. I can file.
No. It's his case. He needs to do it. I guess we're gonna see him regardless tomorrow, right?
Yes.
Okay.
Getting with most witnesses.
Can you put Miss Green's case on for tomorrow, please?
Yes.
Okay, all right. I'll sign your motion. You got
Wait, this order on.
it. You're back. That's okay. It's not a big deal. What's up?
Mr. Holland.
Holland.
She did let me know that I put in another request for the loading.
It's 193 days. We're moving without it. I'm not gonna do it. Whatever's not in now is not coming in. And I'm surprised that it's waived at 193 days old. So we'll set it for all the day that you have next week as well. It's clear trial by next week. Hey, Top of page 10. So they're having issues with the blood, ixnay on the blood A. So it's clear trial at the next setting. If they want PTI, it has to be submitted by the next setting. Same day as the next week for all the other cases.
How long's the sentence?
Just next week, whatever she picked for next week for all the other cases.
Okay.
Judge, for Mr. Ramirez, the MHA 2024.
This is the guy, yeah, we just spoke about it, the fourth time. Huh?
Okay. Just wait a
What's up?
the PR bond?
Yeah, I said, yeah, I said yes. Well, you got to tell Veronica behind you.
Okay. Yeah, but she.
That's okay.
We were also.
But it's for tomorrow at 2 p.m. But yes,
Yes.
yes.
We also wanted to amend the conditions. I talked to her about, it's been a crazy morning, apologies. Amending the bond conditions and the protective order, no threatening or harassing.
For, I don't know. I mean, have you spoken to the complaining witness?
Yes, Judge, that'd be, she's been.
Okay, I need to amend and I need to speak to him though. Is he here?
Yes.
Because I have to admonish him. So, okay, file it and then we'll bring him out and I'll admonish him here momentarily. Yeah, because I have to admonish him. I have to tell him that no threatening or harassing, that we're amending it. Otherwise, he's just not gonna know.
Right, stay in your. Okay. Yeah, fine. Oh, sorry.
Brett, who's your guy?
Robert Stevens.
Okay,
Let me know when you're fine to know if I can.
I'm ready.
Okay, Serena's offered a custom TTI. He's been an inpatient.
Sure.
He's living at a sober living facility up in Richardson, Texas.
Okay.
He's going to probably be there for about another, they think about another 6 to 8 months. Serena's gonna do a custom PTI where he'll basically continue doing after care. And so I just need to get her some documents, some additional documentation. I'd like to come back maybe next week.
Okay, I'm down.
We get
Yeah.
Everything signed and.
Okay.
on is
For sure.
doing that.
Okay, are you gonna follow a supervision order?
It's gonna be like a PCI, it's not gonna be, the DW on the PCI is gonna be a custom PCI.
Got it. Okay, but there will be a supervision order. Okay, sweet. Yeah, for sure. Of course. Hi.
Well, one is the other one first, and I'll follow up. It's ours.
Oh. What was the last? Smith, right? Mr. Smith, come on up. So the idea is that if he goes into this, I guess, treatment, the case will be dismissed. You've got a really great deal going, Mr. Smith. All you have to do is go to the Ed Emmett Center, have an interview with them. And if you do that, this case will get dismissed. You understand? The other thing is I'm amending your bond conditions to allow no threatening or harassing contact. What you need to understand is what is threatening or harassing doesn't matter what you think. It's what she perceives. So if you go up to her and you start going like this, is that threatening or harassing? It is, and it can land you back in jail. Do you understand? I'm going to protect my community at all costs. You've been in jail for how long now?
Over a month.
How was it? Did you enjoy your stay?
No.
Great. It's not supposed to be fun. It's there to show you things. What happens when we act a certain way out there in the free world. When you do, there are consequences to action. Do you understand?
Yes, sir.
Okay, man. Good luck. Did you file it? So we have it? Great. We need them to sign and then we're good. Yeah. You ready?
I'm gonna supervise the first one and then follow.
Okay, come on. Rock and roll.
Bail review for a fugitive case.
You want a bond?
He wants a bond.
Okay.
Would like a bond, for Mr. Solomon.
Do you want to bring him out? What a day. So last name was what?
Solomon.
Solomon.
Can we see?
No, you gotta scroll down. To the actual state. Okay, you don't need to. Yeah, just.
Hey, Victor, how are you, man? Happy Tuesday.
What's that?
Happy Tuesday.
Happy Tuesday. Happy to be here.
Does he have a pool? Oh, it's Ms. Ajay. Okay. We'll do your plea next, sir. Okay?
Thank you.
Yes, sir. You are Mr. Solomon. Good morning, sir. Your lawyer is asking for me to set you a bond. I don't know. You're wanted out of another state. We have to figure out whether we should give you a bond or not. Just because we can doesn't mean we should. So we're gonna get to know you in about 10 seconds to see whether we should or not. All right? State's gonna go through what you're wanted for, criminal history, and we'll go from there, sir. Give it a second and then I'll let you talk, but let's figure out what's going on. I have no idea of anything. Okay,
The defendant has a warrant out of Wood County, Ohio for an FTA for drug possession and trafficking. It was issued May 2nd, 2026. There is another outstanding warrant out of Bowling Green, Ohio as well. It does not specify. There's been 2 previous warrants for him in his past criminal history. He has had
2 fugitive warrants?
2 warrants listed for him by other counties, jurisdictions. He has a long list of violent crime history, armed robbery, felony possession, assault and battery, firearm possession by a felon,
Recent or old?
dating back from 2006 all the way up to
I mean, how recent are the violent offenses? Because that really concerns me. If it's recent, then I've got a problem.
The assaulted charges or the.
he has a felony firearms charge from 2009 in one jurisdiction. There is,
Actually, Your Honor, this is what those look like this. The previous parts were accurate, but their types of FBI numbers, but the ones for the armed robbery are not.
Which jurisdiction wants him? One or both?
one, Wood County, Ohio.
So the other jurisdiction
The
doesn't
other
want,
Ohio jurisdiction, I guess.
they're not,
It could be that they didn't confirm, it could be that they didn't want to pay the money, it could be that they haven't gotten approval from their DA, it could be 1,000 different reasons, but it's all at the sheriff's office station or at the DA stage. So.
I think I can assume what your position is on a bond. Okay, Ms. Kuhn, ball's in your court.
I would ask for a surety bond, which is affordable. Mr. Solomon, Mr. Solomon can afford a surety bond of $1,000. And he'd be able to get to Ohio, he has transportation there. He has family who lives here. He also has connections to Ohio, so he'd have a place to stay when he goes there. He understands that he'd have to turn himself into Ohio within 14 days of being released, and that if he didn't, then there's gonna be a warrant here and a warrant there, and this problem won't go away. I've made this very clear to him.
Just 2 prior fugitive cases?
2 prior warrants out at some point for him, not fugitive.
He's just had.
Your criminal history and the fact that you're wanted out of 2 jurisdictions is concerning to me, Mr. Solomon. If you want me to set you a bond, I can, but it's going to be a high bond. This isn't a revolving door where you just get to walk in and walk out, and especially with the dangerous history. So if I set you a bond, it's probably going to be somewhere in the neighborhood of around $7,000 to $10,000. Has he waived already or no? Do you
He
know?
has not signed a waiver. He would sign a waiver if he could not afford the bond. It's my understanding that he'd be able to afford a $10,000 bond. $7,000 would obviously be preferable. He was not aware that he had these outstanding warrants, and in fact, it does sound like a new charge.
I get it. Nevertheless, you still have 2 different warrants out of 2 jurisdictions, a significant amount of criminal history. So I have to ensure, number one, that this, if we set you a bond, you understand how serious this is, because if you do bond out, we expect you to immediately go back to Ohio. The other problem is I don't want you to leave a wake of destruction on your way back. And with a bond amount, hopefully that's enough of an incentive for you to understand that when we say something, we mean business. You're old enough to understand that actions have I want you to listen for a second. I know you're trying to think of things to say, but you're not going to hear what I'm saying. I don't do this over and over. If I set you a bond, you get one opportunity. If you fail to do what you say that you're going to do, I will revoke the bond, set it at 0, and I will not give you another one. I will issue a nationwide warrant for your arrest. You can't run forever. I will get you, and this time I will hold you until Ohio comes and gets you. Do you understand? Okay, I'll set the bond at 10,000 for what he said he could afford, and we'll go from there. If you want to make the bond, okay, we give you 14 days from the date of your release to turn yourself into Ohio.
Would you be willing to go to $7,000?
No. He's got 2 open warrants in 2 different jurisdictions, a lot of criminal history, and it's violent. So if your other option is if you want to waive extradition, we give the demanding jurisdiction, Ohio, 14 days to come get you. If they don't come get you within that time, Harris County releases you.
Your Honor, I need to reach out to his family on his behalf
Okay.
to ascertain that they deal.
Sure.
And then we'll make that decision.
We'll give you time, as much time as you need. Understand, though, that while you have refused, the clock for them to come get you, you've not waived. So you either waive or refuse. If you refuse extradition, the clock is not ticking for them to come get you. So the 14 days is stalled until you either waive, or I guess, yeah, just until you waive. At that point, that 14-day clock will start ticking for them to come get you. Do you understand?
I'm gonna talk to you about his family before you say that.
Okay. If he doesn't want the bond set, then just let us know. We can have him do the waiver and then go from there.
Very briefly, Judge, on the other one, I just want to, I was mistaken. I thought it was under chapter 51. It's not, it's under chapter 17. 1703 is what prohibits personal bond because it's not one of the enumerated ways.
Are you talking about with,
Well, just in general, in all bonds, it's under 1703. I thought it was under chapter 51. I was mistaken. It was 1703. So because it's an administrative case, it's not one of the enumerated offenses of personal bond can't be granted to cases.
show me the section so I can see it.
Well, so I printed all the other ones except 1703 because it didn't print, but on the list of 1703, I'll obviously.
Okay.
Section mark. I checked with Megan just to make sure I wasn't going crazy, but.
And then you take a look as well.
That might be at the magistrate level that you're not able to.
It's okay. You've got time. Take a look. We'll take it up tomorrow morning. That way you have enough time to look at it. I'm not going to make a decision until at least you take a look to see, so you do your diligence and.
Thank you, Judge.
Yeah. Okay. Okay. All right. Good luck, Mr. Solomon.
Jordan?
Brent, what's up?
My guy, are you okay if we can do everything remotely, and have them sign?
Sure,
And
of course.
everything, so.
I trust you.
Have to appear
Yes,
personally?
I trust you.
Thank you, Your Honor.
All right. Good morning. Oh, we need a train. Oh, there you are, Luis. Good morning, Mr. Presa. Sir, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is 30 days in jail with credit for the 16 days that you have done. You need to understand something very important, that this is now will reflect as another DWI conviction. If you ever pick up another DWI, you will be facing a felony charge of at least a minimum of 2 years in prison, a maximum of 10 years in prison. You understand? If I were you, even if you have a sip of alcohol, I wouldn't get into a car. It is a huge risk. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. You can never take it off. You understand? Is this what you want to do? How do you plead to the offense of driving while intoxicated, second offense? I'm going to find you guilty. I will follow the agreement. I'm going to suspend your license or ability to get one for 1 year. Do not drive until you get a license. And good luck to you, sir. Thank you. Good to see you. Yeah.
Miss Jensen?
Yes. Hey, yes, of course. Hey, Vic, you want to go through the list?
Yes.
Victoria, you want to go through the list?
So can I give you a case number? It's off topic.
Yeah.
26.
Okay.
0484.
Okay.
Came in early because it couldn't make it on Monday.
Let's come up. Did you get the cause number, Shan? You got it?
It's just not the internet.
Yeah. All right, you are Mr. Canales.
Yes, sir.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Judge, our system is like damaged. It's loading.
Judge, he was, I believe THA.
Oh, you got a clause number?
Yeah, 2630484. Oh, so we've already done probable cause?
Yes, he was THA.
Am I just loading?
I don't have bond conditions signed, or let me see, maybe this is it.
Yeah, they're there.
This is an old case. All right, Mr. Canales, do you have a lawyer?
Not yet, sir. I was gonna ask you about getting a board attorney.
Why?
Can't really afford to put money down on one right now.
Why?
I'm not currently working very much. I'm doing DoorDash. I just got the vehicle back.
You're not, you signed an affidavit not to drive. You don't have a Texas driver license, sir.
I do, it's eligible now. I paid the suspension.
You're supposed to come talk to us.
I did. I called the court and she said as long as it's eligible, then I can drive.
I have a court order and I have to undo the court order. No one can tell you anything. We document everything. You cannot just come here and say, oh, I talked to someone on the phone. Who did you talk to?
Whoever answers the phone whenever I call.
Santa Claus? Right. This is a court. We work on proof, not on spoken word, not on the gospel. We work on evidence-based decisions, and we do stuff in paper. Publish or perish. You understand?
It's showing cancel. Unless, but I'm showing like a Louisiana, we're trying to run the, if there, if he does have anything available that we look at, we can run that number. But right now, just running what we have in our system is cancel driver's license.
I can show you on the website where it says that I'm eligible. And I have an SR22, I bought insurance.
So I cannot give you legal advice and I cannot talk to you about the case. I just look at what they tell me as far as the DPS system is concerned, and we make decisions on that. So
And I did find another number that we're trying to run it right now.
this is why you need a lawyer to represent you, to navigate through these. You don't do stuff on your own. When you do stuff on your own in the criminal justice system, it tends to not work very well and in your favor. Do you understand? Right. It's now nearly 12 o'clock. So let me ask you this. Did you speak to any lawyers
No, I haven't spent.
So how on earth do you know that you can't afford one then? If you've not
I
even
got a
spoken
bunch of
to not,
advertisements since the court date, whenever I came up here.
okay,
And it's
did you
all like
call,
thousands of dollars.
but did you call any of them? That's a
I
no.
called the court to ask if I could apply for a court appointed.
Everyone wants a court-appointed lawyer, and I have very limited resources. I don't have unlimited resources. So we really have to see who qualifies for a court-appointed lawyer, and it's based on the federal poverty guideline, meaning that you make around 17,000 to 18,000 a year to qualify. We don't just give out court-appointed lawyers like it's candy on Halloween. You have to qualify. So if you're making thousands of dollars a month, from whatever means it may be, you're just not going to qualify for one.
Judge, we have an update. We were able to find a different driver's license number for him that does show that it is valid. It expires in 2033.
Okay.
We have a no liability insurance hold that was listed on 7/24/2020.
So he's valid now. Is it a Texas or is it Louisiana? Okay.
Previously was Louisiana, but now he has a Texas driver's license.
Okay, let me make a notation now. So I will take off the no driving affidavit so that you can drive legally. Just make sure that you have liability insurance because that's required by law. All we ask you to do is follow the law. You are not allowed to be in possession of any weapons. You understand? I don't care.
The evidence thing I had, I'm trying to get.
This case is open. I have put bond conditions that you're not allowed to have any weapons. Please don't have, okay?
They also told me to wait till the court date to ask them for an attorney. Yeah.
How much money do you make a month, Mr. Canales?
I haven't worked in a couple of months because I wasn't.
You were, but you told me that you were door dashing and that you were.
Right, that day that I had court, I had bought a car the day before with the last on the
So you have enough money to buy a car?
Yeah, so that I could.
What kind of
I
car
didn't
do
know
you
my
have?
license was suspended until.
I'm not going to talk to you about the case.
Yeah,
I
okay,
only
sorry.
want to know whether you can afford a lawyer. So you just
Right at the
recently,
moment, I can't, not before court.
you just recently bought a car.
Right.
What did you buy?
It's a 2006 Honda CRV.
Okay, so let's do this. It's now noon. All our lawyers are gone by now. I can send you home with an application. We can have you come back. I need you to fill it out. I need to know everything about you, how much money you make per month, how much money you have in the bank, what kind of cars, property, stocks, bonds, mutual funds, IRAs. And then I'll take a look to see whether you qualify. But it's evidence and it's income based as to whether you qualify. Every single person that comes in here wants a court appointed lawyer, and we just don't have resources to give it to every single person. I just don't. Right. Just everybody thinks that, okay, I just caught a case, I'm just gonna get a court appointed lawyer. It doesn't work like that. You have to qualify. Deputy Williams will give you an application. We'll set you off for a couple weeks, and you come back, have it filled it out, and then we'll check it out. Okay? Please.
You just want to keep that day and worry that things out.
Well, that's what I'm gonna ask about changing that date.
Oh, okay.
So one time, I think I'll just.
I was on board.
We went down for an entire office.
No.
Wasn't it? At least we're, the orientation was down for an hour, so I assume that we're down for. Wasn't that bad?
When you find the back of the chill out.
I guess we'll talk about it. Hey, Mr. Johnson, how are you? You can't, no one does anything, no one cares. I know, I feel your pain.
Terry Leonard, I was just playing a few minutes ago. He's in
Back there?
custody, right?
Okay.
Yes. Leonard, Terry
Leonard.
Leonard is his name.
Okay,
I don't know if we got a PC on him yet, so.
do you want to do PC? It's already done through the magistrate, but if you want to redo it with me, I'm happy to do it.
Definitely, I'll love to see.
Okay, Leonard.
More reasonable approach to things. No, I just got appointed before the campaign.
So he's on deferred for PCS, has R2, and then, oh, man. Picked up the case upstairs too. Okay, you ready?
I hadn't got, oh, I just got the appointment email, well, so I can see the call number two. Try.
Yeah, she has the. But this one, I don't.
Yes, so that we got email. That's what came out.
Hey, you talking about bottom of two? Hey, you talking about bottom of two?
Yes, Judge.
So I guess a couple weeks to make a decision, but dude gets an ankle monitor today.
Okay, you're gonna.
Yeah, the case is 2,000 days old.
Okay, yeah.
On Almaraz.
Filling in for Marco on it.
Yeah, that's okay. Mr. Almaraz, your next setting is plea or trial. It would be a good idea for you to go through the evidence with your lawyer, but that is the last reset that you will get. Do you understand?
Yes, sir.
Okay,
I will acknowledge you told me, Judge. Okay.
you ready?
Yes, Your Honor.
Okay.
On August 2026, at approximately 12:25, officer observed and measured a white Nissan Roof bearing a Texas license plate, speeding 70 miles per hour in a 50 mile per hour zone eastbound on San Luis Parkway, Harris County. Officer initiated a traffic stop and discovered the defendant had no driver's license. Officer instructed the defendant to exit the vehicle. Officer then performed an inventory search of the vehicle and immediately observed the butt of an unholstered handgun positioned between the driver's seat and center console.
Yes, for the unlawful carry.
Why would he just start searching? Is he black? He's driving while black or what? It's a suspended license case, right? I mean, was it in plain, what, was it plain view? I mean, I'm down with the suspended license case. I think that that's a good case, but the gun case,
There you go.
I don't think so.
Judge indicating that he's been saying that he was going to do an inventory search of the vehicle was going to be towed. So it says, a fine informed the defendant that the vehicle would be towed and place him in the rear of the fines patrol vehicle, and that's when he did inventory search of the vehicle, and that's when he found the gun.
Did he file an inventory?
As he was going to arrest him because of the history of multiple DWLIs.
Oh, I don't see multiple DWLIs, but nevertheless, because when Shanthia read it to me, it's just, I pulled him over, I'm just gonna start searching.
No, so, from what the DIM summaries indicate was that the officer conducted the traffic stop for speeding. After reviewing his criminal history, revealed that the defendant had multiple prior convictions for no driver's license and failure to maintain financial responsibility. The defendant's most recent conviction, was on May 19, 2016, out of Harris County, Texas. He had a total of 4 prior convictions for no driver's license and 4 prior convictions for no vehicle insurance. Officers requested for proof of insurance. Defendant was unable to provide it. They asked him if he had any weapons or anything illegal inside the vehicle, to which he denied possessing either. Officers then told him to exit the vehicle, observed him remove the upper portion of his seatbelt from his body, revealing that the defendant had not been properly wearing the seatbelt and had instead been sitting on top of the lower portion of it. While completing the traffic stop, officers were preparing citations. They gave him ample opportunity to provide the financial responsibility. He did not have it. So they told him they were going to tow the vehicle and place him in the rear of the patrol vehicle.
Okay.
For arrest.
I mean, that's better than how you had initially read it. I mean, okay. All right. I mean, there's PC.
Understood.
Yeah.
You requested inventory, the copy of that inventory that was filed.
Yeah, if we do, usually have a tow slip that they might, put in there, I will request that.
It was actually inventory, they'll have an inventory.
So where did the bribery come from? Did he, is this out of, it's out of the same? Yeah.
So after the inventory search, the defendant was on a phone call with an unknown female. The defendant stated, he's searching my car, mama. The female replied, is the gun in there? The defendant immediately turned the speakerphone and stated, I can't hear you. And then said, yeah. The conversation provided defendant with knowingly possessing a firearm. Let me see about anything in regards to.
I mean, it doesn't really matter. It doesn't.
Oh, here it is, Judge. The defendant subsequently offered a fine of $2,000 in exchange for releasing him from custody. The defendant specifically stated, bro, I'll give you $2,000, bro, take me home. A fine stated he couldn't hear what the defendant said, and then the defendant repeated again. I said, I'll give you $2,000 if you take me home.
Okay. The bonds are set pretty low. I'll leave him as is. He's got other things to worry about regardless. So whatever you want, I'm down. Yeah.
See that little now, or are they running?
His bond right now is $500.
Okay. Thank you, I appreciate it.
Okay, thank you, Mr. Jones. Are you guys waiting on us?
Oh, were you calling us?
Yeah, yeah. I'm ready for you if you need me.
We just wanted to confirm that Mr. Solomon would like to have his bond set at $2,000.
Okay,
That's it.
I'll set it at 10. All right.
Mr. Allen's device, is it GPS or screen?
GPS. It's,
He currently has a GPS, it's a felony.
oh, he's got a felony case too?
You did your communication. I already know that because of the vehicles and we have.
Yeah, I know, just a GPS monitor. Yeah.
Oh, you know, I'll talk with Shane. I'll be back. And then depending on anything.
Approach on use regarding Daniel defendant,
Regarding who?
a Daniel Reed. Last name.
No. What was it? What was the lawyer's name? He approached on several people, but I don't remember what the defendant's name was. What's it regarding? The name change? No, that's the other dude. What is it? Did you talk to Sebastian regarding Reed?
He did not talk to me.
He wants, what is it, medical record? No. It's like
Order to obtain medical certificates.
order to obtain medical certificates. Read.
It's usually Lawrence Chambers who handles the mental health commission. I'm not sure if they're all done.
Yeah, I guess if you want to check with Sister
Yeah, I
Lauren,
can double check with Lauren.
see if she's okay with it, and then if she is, then I am. Hi, Lisa, I see you. What's up?
Judge, I had Mr. Lucille on the docket today.
What's the last name?
Lucille, Raymond Lucille. Yes.
Okay.
A month ago, we received an ARA and he updated, I sent the copy of he's enrolled in both BIP and parenting classes. They're starting like this week. And I sent copies of that to the DA yesterday and to Victoria this morning.
Lucille is the last name. Does he have 4 classes done?
No, because when he had to go through Harris County to get all of it set up, and they enrolled him. It starts this week, I think, is his class, when his classes start.
Oh my
The
God.
email he
This
sent me
case is
was,
gonna be forever.
well, we only received this a few weeks, like 3 weeks ago, the ARA, or a month ago. And I think he went right away and
I
tried
have
to
it that July 21st is when.
right, so that's like a month ago. I think I got a letter from him that said that that probation is the one who set it up for him. So I don't know if he had to go through probation to get it. Yeah, that was the email that he sent me with something. It had a document attached that said he's registered for both classes, but they start like later this week.
Okay, I mean, it's really old, so I'm not doing long recess to see whether he complies with it. If he misses one class, tell him he's out because it's old.
I'll let him know.
We'll give you 30 days. He's
Okay.
got to have at least 4 classes done by the next setting.
Okay, I will let him know. Thank you.
Hold on, I have to get your date.
Yeah.
30 days, Judge?
Yeah, on bottom of 13.
All right, how's September 24 or the 30th?
The 30th works.
Okay.
Thank you.
Required, always required because it's old, and in the event that he doesn't comply, then he's got to be here. Yeah. All right, Lisa, we'll see you.
Okay, thank
Have
you.
fun.
Bye-bye.
Bye.
He's signing in. Yeah, mine just started looking at the reset it.
Hi, happy Tuesday. What's up?
I have one on docket today.
Sure.
It's Amanda Phillips.
Phillips.
She's in custody.
Okay. Anything in particular you'd like?
I guess first you have to get please get a PR on.
Did you just get appointed on it?
Yes.
Okay, what say you state? What's your position? Phillips. Is she on bond for anything else?
No, she doesn't, she only has one prior arrest from 2023, it was a criminal trespass. She has no violent history.
So let's read this, because usually most on a first offense get out.
Right.
Unless there's some kind of, I don't know. So I'm going to read to you where. This is the reason for the bail decision. GOB eligible as charged mismarked by the district attorney's office. So PTRB granted with bond conditions entered to reasonably ensure community safety. She was given a PR bond.
Yeah, she did tell me she refused it initially.
She refused it.
Yes, and then she changed it. Because she expressed to me that she wasn't sure she would be able to make it to court the following day. It's a short amount of time.
Well, they usually give them a 7-day setting.
That's what she did.
Do you mind bringing her out? Phillips. Have you spoken to her? Have you spoken to her yet?
There may be potential
No potential what?
mental health concern. Just
I get it. My only concern is, does she have a place to go to, or is she on
she
the?
said it would be like a family member. She gave me her brother's number, so that's what she expressed.
Okay. Who's the complaining witness? Ms. Shaw.
It's her father.
I'm surprised it's not upstairs. I'm surprised it's not upstairs, huh? Maybe it wasn't bad. I don't know.
Somebody else, I believe, was involved, and one of her cousins who is upstairs.
Oh, so there's a co-defendant.
I don't know if they're critics, but somebody else was.
All right. Well, I guess we'll figure out. Good morning, Ms. Phillips. I'm bringing you out because I'm trying to figure out where we should go with you and the case. You stand charged with assault of an elderly or disabled individual by contact. That's why.
Yeah, and he was said we had told them he didn't be okay.
We'll get there. You're facing up to a year in jail and or $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay?
On 8/20/26 in Harris County, Texas, officers were dispatched to a disturbance call and made contact with defendant and complainant. Complainant is the defendant's biological father. Defendant was accusing complainant of causing her mother's death, who's CW's wife. Defendant began to make offensive contact, such as kicking him multiple times in the shin, slapping him in the face, striking him in the body and attempting to kick him in the groin. Complainant stated he did not feel pain, but stated that his daughter should not be hitting him. Complainant wished to pursue charges and a protective order. Complainant is 67 years old.
Is this a Class C assault that's elevated to an A because of the elderly? Or is it a true Class A? Because if there's no pain, it says on August 20th, the then and there unlawfully, intentionally, knowingly cause physical contact with the complaining witness by striking the complainant with her hand, and the defendant knew or should have reasonably have believed that the complainant would regard the contact as offensive and provocative. How on earth can you get in someone else's mind? It is further presented in Harris County that the defendant heretofore on about August 20th, the then and there unlawfully, intentionally, knowingly caused physical contact by kicking the complainant with her foot, and the defendant knew or reasonably should have believed that the complainant would regard the contact as offensive and provocative.
They changed it like this because he said that he didn't feel pain. So they're dealing with him.
This is a first for me. Phillips. It's an assault where you don't have to have any kind of injury or pain. That's a Class C.
Yes, but I think it's enhanced because of the enhancement paragraph is because of the elderly individual. So that enhances the judge.
I'm going to find it for now. If you want to do any kind of research to see whether you think it passes muster or not, just let me know. And I'm willing to, hear it in a week or 2 weeks, whatever you want. Ms. Phillips, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you are not allowed to have contact with this complaining witness. Do you understand? If you violate this condition, I will revoke your bond and put you in jail. I'm entering now a protective order that identifies Mr. Phillips as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat, harassing behavior. You cannot be in possession of a weapon. You understand?
I understand.
Okay.
Another,
Do you want a PR bond, ma'am?
I would like to.
Okay, just look at me. I want you to understand something. This is not a revolving door. Everybody deserves a chance, and I'm going to give it to you, and I'm going to give you a PR bond today. But this isn't something where you're going to get PR bond after PR bond. If you pick up multiple cases, it may not go well between us. Do you understand?
Yes.
Okay, all I'm asking you to do is be patient with people. It's not hard. If you're upset at someone, walk away, go outside, but just don't have contact with this person. All right? The only other thing I'm going to ask you to do is stay in contact with her so that you guys can always remain on the same page. As long as you remain in contact with her, I'm going to waive your appearance for the next couple settings, meaning that you don't have to come back. But if she tells me she cannot get a hold of you because you're not responding to her, I will issue a warrant. Do you understand?
Yes.
What is your question?
I don't have a formal contact.
As long as you have a place that you're staying, like your brother's house, a sister, an email, it is your responsibility to stay in touch with her. not anyone else's. Do you understand? Okay, all right, so we'll have her sign them up. Can you create the bond conditions? We'll have her sign it and then I'll grant you the PR. Yes, ma'am.
No contact.
No contact, no weapons. That's, and then she'll sign the PR bond or the bond.
I have the photos to make sure, but it's 2241A3C. That is the salt class A with an L.
Usually the enhancement only brings it up one level though, right?
So under this closure.
Well, yeah, there's only a class C or class A. There's no class B assault. But it's only one level of enhancement when you enhance something. It's weird, right? It must be, I don't know. It's first for me. I've never seen that. Hey, you want to stay here all day or what?
Yes.
I thought you did. Come on.
Bottom of 5. What's going on with that? Council is here, defendant.
Wait, what was the number?
I'm sorry.
Cruz.
Cruz is the last. The council was here and she said something about disposing of the case today.
It's a guy
They're
that's,
partners.
Oh, yeah.
She
Yeah,
put that
she's
up.
completed,
oh, did you dismiss it?
yeah. I believe I did, but you don't have a business on you?
Let me look.
Okay, I'll file it.
Okay, they're gonna dismiss it.
The next one is top of 8. Is that for Rainier Township here?
2501.
Bottom of 9. It's a PCI, PWR PCI. Oh, dismissal filing. Oh, right. Page, page 11. Last name Jordan. So Karina said she felt it was complete, but then Leonard said it wasn't. Jordan? Yeah, I forwarded that email to you. I want to confirm the reply.
It's only 63 days,
Yeah,
right?
it's very young, but if it's complete, it's complete. It's move along faster.
What's the deal, Pickle?
I'm looking right now.
Right. I like to move
He
it,
said
move
he's
it.
missing, he's requesting post list, guys, so I'll pull up the information to see what we don't have, because he said he's missing.
A co-slip
And 12 paperwork.
on the interference?
And he also mentioned something about wanting discovery for the previous case.
But didn't you offer a PTI?
Pulling it up.
And didn't you say he accepted a PTI?
No,
Oh,
saying that it's missing discovery.
okay.
There was a clarification.
Yeah, so that's what he was requesting is not normally done, so it's like additional discovery he's requesting, so we will have to, our discovery is complete, he's requesting additional discovery.
Okay, not a problem. It's only 63 days. I don't care. I don't care. No.
Okay,
I watched Harry Potter last night. I don't care.
Judge, you want to stay here all day?
Touche.
Page 16, 2 bonds posted.
5002.
Yeah.
Yep.
That's on Parker.
P,
888.
16. Okay, who's next?
Bottom or top of 24 is a required hearing. The council said defendant is MIA.
Which one?
top of 24.
5001.
And Stacy has bottom of 27.
What's the deal?
Your Honor. Yes, the state offered us a PTI yesterday, and actually today they offered us a shorter anger management course.
Great.
I did talk to the client, however, if the court could explain his options.
Tingle. Go around. We don't want you next to the DAs.
How you doing?
Pretty good. How are you, Mr. Tingle? There's an expression that goes, never look a gift horse in the mouth. Have you ever heard of that? So what that means is that, you know, when someone may be offering something to you, you know, be careful what you wish for in this life. You know, it may tend to backfire because you never know what's going to happen in a jury trial. I've been in jury trials where I thought it was slam dunk guilty, where they came back not guilty. And I've been in other ones where I thought it was the other way around. You were set for trial today. They've offered you a short anger management class, like a 2-hour. If you do a 4-hour anger management class, literally you leave here, do a 4-hour anger management class, provide her the certificate, they will dismiss this case. Whereas if you still want to go to trial, I'm happy to do it, but I'm not going to accept any more offers after today. You will go to trial, and you never know what happens in trial. I don't want you to make a decision now. You talk with your lawyer, you guys go outside, figure out what you want to do. If you want to set it for trial, or if you want to keep it at trial, I'll set you 30 days from today. We will go, but I'm not taking anything else. Do you understand? Okay, you guys talk.
So that the court is aware, it's anger management and effective decision.
Yeah, but those defective decision-making lasts for like 2 hours anyways.
It's more than 3 hours, Judge. That's how I
It's
personally.
drop in the bucket, really.
I did inform counsel that we did get a call from the complainant this morning that he was on his way. We advised him that he didn't have to come in because we're gonna go on another trial, so like the complainant is on board with the trial and everything.
You make the decision. It's up to you. Yeah, okay. Okay, thanks. Let me know. Yes, ma'am. So if you still want a trial setting, just 30 days from today.
Okay, sounds good. Thank you, Judge.
All right, I think that's it. We're done.